started late. The traffic was an impediment, and therefore I had to make all of you wait. My profound apologies for that. Grateful that the honorable judges and the police officers could come here and take part in this deliberation. It is very important. If you see the data with regard to the POCSO cases, it's alarming in Sikkim and it's very, very disturbing. This has been in my mind right throughout, and we need to take very, very urgent and cogent steps to ensure that our children are protected. But how do we protect our children if you do not know how to protect them? So it is important for each of us to know how to protect them. What is the value system which is instilled in the POCSO Act, which has to be considered by us and taken forward? These are very, very important issues. But then today it's a kind of a unique situation where the honorable judges as well as the police officers are together, assembled in one fora to discuss and deliberate the way forward under the POCSO Act. And that's where I need to flag certain issues before the presentation. In my understanding, limited as it is, what is the role of a police officer while investigating a case? The investigating officer, the investigating agency, is to ensure that the truth is unearthed. For that, you will have to bring out the evidence, every type of evidence that is available, to ensure that truth comes out. Now, truth is a very, very difficult word, and we keep talking about this in many occasions. Truth may not be what is written in the FIR. Truth could be something completely different. So, it is your job to ensure that the truth comes out. And to that, you will have to investigate and produce every reliable evidence to ensure that justice is done. That's the role of an investigating officer in a short thing. What is the role of a judge? The judge is to analyze these evidence and come to a conclusion about the evidence that you have produced before us, and to give a conclusive determination of the issues before them. So there is a defined and very clear role demarcated for the judicial officers and the police officers. And I see sometimes, and when I keep reading judgments and start thinking about what is happening with us, maybe I feel there is a confusion among the police officers as to how evidence is to be produced and collected. On the last time we had a deliberation, I don't know how many of you were there in the last deliberation which we had with the police officers, but what I realized, and which I did not know about, is most of the police officers do not have a law background. So understanding of the law of evidence is a task. We need to therefore, I think, focus more on how evidence is to be collected, how evidence is to be placed, and how evidence is to be placed in such a way that the judges feel safe to rely upon the evidence produced by you and give their verdict. That is very, very important. If you, and many of you, I don't know whether you read our judgments, but I'm sure many of you do. When you read a judgment, I think there is a little, thing which needs to be clarified. And that is the segregation of the role between the investigating officers and the judicial officers. When you produce evidence, you have to ensure that the best evidence is produced. So what is best evidence? If you are coming out with a document, the document needs to be proved. Firstly, how do you prove that document? A document needs to be proved through reliable evidence. But what is reliable evidence? The primary evidence. What is the primary evidence? The very first document, that is the first copy, not the first copy, the original itself. That is what is needs to be produced. But who has made that document? It is under whose signature? Now, if you get the person who has made that document and produce that particular person to prove this document in as a witness, then you will prove that document. If you do not do that, the judges will have difficulty in appreciating it. So it is very important for you to ensure that every material evidence that you produce is backed by reliable evidence. A documentary evidence needs to be proved through the maker of that particular document. Right? That's the role of the police officer. But when we in the judicial side examine it, right? Take a simple example of the confusion which we have had over a period of time with regard to the birth certificate. You know, and this is something which I have been grappling with for a long period of time. Now, birth certificate, okay, is, if you look at the birth certificate, there is a process of how the birth certificate is prepared. And if you just think, it is important for us to think how it is prepared. The person who is putting the entry is a registrar in the birth certificate. The registrar actually has no physical idea of the birth. He has not or she has not seen the birth happening, right? It is some information collected from somebody. So how is that? If you go and analyze the act, the Births and Deaths Act, you will find that it requires a certain process before that entry is made by the registrar. Information has to come to the office of the registrar. Information from people who knows about the birth. Who are the people who know about the birth? The parents. So one of the parents could be the informant. It could be the hospital employee who has knowledge about the information. He gives that information. Now that is put in a register, right? That is put in a register, and that register gives all the details with regard to the birth of the child, right? But that person who is putting that entry has got that information and kept it somewhere. That's a very important source of your information collection, right? The register is a very important source of evidence, right? Then it is only on the basis of that entry in the register that the registrar is authorized to issue a certificate, right? The certificate is issued under his signature. Now, this is where the confusion comes in. When the certificate is signed by the registrar, right, under the Act, it becomes a public document, right? It becomes a public document, therefore the judges will say it's a public document, no requirement of any further evidence. Which does not mean that the investigating officer must back out from investigating. Merely because you've collected the birth certificate, you should not be judges. You should make sure that every information which is there available is collected and placed before the judges, so that the judges can analyze it and come to a very conclusive finding with regard to the age of the person. Do you understand the difference between the two kind of thought processes? A police officer cannot stop. If you read some of our judgments, you will find, oh, it is public document. Birth certificate is a public document. No need for any further proof. The certificate is good enough. That's what we say in our judgment, right? Does that mean you stop your investigation there and just produce the birth certificate? You should not stop there. So make it very clear in your head that the role of the investigating officer is to ensure that the truth is unearthed. Now, how do you unearth the truth? by collecting every material evidence available to you and placing it before the court. To make it easy for the court to appreciate and find the truth. Truth is a very, very difficult task for judges. In POCSO cases, I have seen that, and yesterday I was discussing with the Deputy Director, many of, at least 70% of the appeal that come to our court and the High Court is by an accused who is challenging the only one material fact. They say that the child's age is not proved. So the first question we ask the learned advocate, what is the alleged age of the child? They say 3 years old. They say 4 years old, 6 years old. Now think, is it difficult to see a 3-year-old and come to a conclusion that the birth child may be 3 years or 4 years old? Physically present before you, right? And that after a whole trial, in the trial court, the advocate for the accused comes to the court and says, look, they have not been able to prove the age of the child. So I am questioning this verdict. There is a verdict of conviction, but the age has not been proved. It shocks my conscience. Then what has happened to the investigation? Then what has happened to the trial? Where have we gone wrong then? And suppose I have to now release the accused on this ground, that a child who is just 3 years old, his or her age has not been proved by the investigating officers during the process of investigation and by the trial court during the process of trial. That's 3 years, 4 years of absolute agony of the victim. The victim has already suffered the consequences of an action by the accused. The victim is suffering a whole process of investigation where you are questioning them. You are subjecting the children to medical examination. You are subjecting them to all kinds of things which is important for them, isn't it? To ensure that justice is done. But for the victim, it's an agonizing process. And then it goes to the judges. A trial takes 2 years, 3 years to complete. Again, the victim is brought before the judges, before an alien atmosphere, completely different. Most of them are happening in the rural areas. They have not seen even a government office, leave alone a courtroom. They are brought to the courtroom in a completely different atmosphere. Again, subjected to be examined, cross-examined by people who they have never seen in their lives. Look at the kind of process, suffering they will have to do, which is a mandatory requirement under the law. And in the end of this, a verdict of guilt comes and an appeal is filed, and the question is, has this investigation and the trial conclusively proved that the child is a child? And the accused is actually questioning the whole process. So where are we going wrong is something which all of us need to consider and think. If you do not think, then it becomes very, very difficult. POCSO Act, as you see, is a special act. A special act is to be done by special people. All of you have to be experts in this field. You have to have the sensitivity, you have to have the understanding of child psychology, you have to have the understanding and the ability to ensure that justice is done by a process which does not agonize the child. In many cases, I have seen that the children, female child, female victim, are still subjected to two-finger test. We've said so in our judgment, the Supreme Court has said it many a times, but they still indulge in it. You have to ensure that that is not done, because at the stage of investigation, you are in control. Many of the doctors may not realize it, they are doing their duty, right? But you will have to tell them that this may not be permissible. It's very, very important that we need to be sensitive to the traumas of the victim. You know that the POCSO Act is gender sensitive, right? So it is absolutely gender neutral. If you just go back and start thinking as if you were the child and you were that victim, maybe our understanding of how to deal with it would be better. You have to put yourself in that place. But do not replace your role. To understand is one thing, but to get into the role is completely different. So make sure that you understand it with that sensitivity, but do your job as a police officer. But the police officer cannot be a normal police officer in a criminal jurisdiction, because POCSO is a special jurisdiction. Therefore, the nuanced understanding of the POCSO Act is very, very important. So if we understand our respective roles as an investigator and a judge, perhaps we will be able to deliver justice much better. With these opening remarks, we will just go in for the presentation, and after that we will start the discussion. I want each one of you to participate in this. I want each one of you to talk about it. Let us discuss the problems that all of you face, and let's try and resolve issues here. Okay?
Everyone, though everybody knows me, but still I would like to introduce myself. I am Ramyam Chaudhan, Deputy Director, and I will be assisting Lordship today for this session. And I would like to seek permission of everyone to give my presentation being seated, because I have to refer to the books also. So if you all don't have problem, then I'll sit and give my presentation. Okay? And also now, as Lordship have already said that today the participants are from the judiciary as well as from the police. So not deviating from the schedule, we are sticking to the schedule, but we have tried to make the presentation in such a way so that the police does not get confused with the role, what they have to play with that of the judicial officers, because judicial officers have a different, have not a different role, but have a role different for appreciating the evidence which is collected by the police officer and presented before the court. So with that, I would like to start my presentation, and so the presentation is, you all know that the program is on POCSO. So when it is about POCSO, you have to understand that it is with regards to offense, sexual offense against a child. So what is child? Everybody knows what is child, but still I have put in here, because Article 1 of the Convention of the Rights of Child defines child as a person below the age of 18. And so also the legislation in India, like POCSO, Juvenile Justice Care and Protection Act, and the Information Technology Act also defines any individual below the age of 18 as a child. And the second thing which is there in the schedule is regarding the protection of the constitutional and legal rights of the child. So our Indian Constitution has already provisions are provided for safeguarding the rights of the child. And first one would be Article 14, which talks about right to equality. It protects the rights of the children so that their dignity and integrity is not exploited. And the second, 15.3, which is also very important because it gives the power to the state, authority to the state to enact the law and make special provisions for women and children. It talks about no citizen of India to be discriminated on basis of race, caste, sex and religion. So then Article 21, it guarantees the rights of life, which must be free and dignified in accordance with the law and is also applicable to children. And then 21A talks about right to free education. It ensures that every children is provided free education. And 23 talks about prohibition from child labor, and directive principles of the state policy is also there, which ensures that Article 39E and F ensures that the state has to ensure that the worker's health as well as the health of his children, men, women, and the rights, they have the right to livelihood and healthy life and also dignity and protection from exploitation. Then comes Article 45, which also talks that the state should provide early childhood care and education for all children until they complete the age of 6. Then also it is not only the duty, there is also fundamental duty under Article 51K, which ensures that every citizen of India who is a parent or a guardian to provide opportunity to provide education for his children who are between the age of 6 to 14. Right to free education also says that any child below the age of 6 to 14 has to be provided free education. Now, beside this constitutional rights, there are legislative frameworks also which protects the child rights, and they are BNS, Bharatiya Nyaya Sanhita, which is IPC previously, then the Juvenile Justice Care and Protection Act, then Child Labour Prohibition and Regulation Amendment Act, the Right of Children to Free and Compulsory Education, Guardian on War Act, Prohibition of Offenders Act, Prohibition of Children Marriages Act, Protection of Children from Sexual Abuse, and there are many other acts also which I have not included, but these are some of the acts which also talks about child rights or protects child's right. And here mostly, since the presentation is on, the training is on Protection of Children from Sexual Offences Act, so we'll be dealing with this particular act. And before we talk about what is there in the act and what roles and responsibility each stakeholders have, first of all, like Lordship said, that any legislation, when we are talking about it, we should also understand the intent, why it came out, what was there previously which was not there, what was the act previously, what defect was there in the previous act, and why the new act was required to become up. So we have to understand each and everything before trying to implement the act itself. So first of all, POCSO Act. What is POCSO Act? Now when we talk about the history of POCSO Act, so prior to enactment of the POCSO Act in India, there was no any specific legislative framework which dealt with sexual offences against, crime of sexual offences against child. So Indian Penal Code was there, but which did not specifically dealt with each and every aspects of the sexual offences against child. And under IPC there was no proper distinction between the child and the adult when it in terms of punishment for the offence. And also there was no any account for special psychological or overall development of the child. And also we have to see that in IPC there was chances of secondary victimization of child again in the court of law, because there was no any proper rules as such provisions for child-friendly atmosphere in the courtroom. So because of that, a need was felt and to come up with a comprehensive legislation, like I've written it there, comprehensive legislation to provide protection to children from sexual offences. And in the preamble, if you see, mostly it talks about sexual harassment and child pornography, sexual abuse. So for that, a need was felt to come up with this legislation, and also to keep the best interest in child throughout the investigation as well as the trial process, and also to make a child-friendly atmosphere while recording the evidence, taking the evidence from the child, and also police from the day one, from when the offense is reported, has to ensure that they take a child-friendly approach. And even the court also, once the case come up before them, has to take a child-friendly approach. And also this POCSO, it intend to establish a special court for the speedy trial of such offences. So because of that, this POCSO Act came into being. And then if you see, India is a signatory to Convention of Rights of Child, which is adopted by United Nations of India and accepted by India on 11 December 1992. And like I said, Article 15(3), it gives the state the power to make special legislation. So like Lordship said, this is a special legislation we have to keep in mind. And while implementing this special legislation, like I said, it is very important to understand that keep whatever the intention of the legislation, why the act came into being, by the stakeholders, whether the police or the judiciary or the social workers, CWC. I will mostly be referring to police and judiciary because here the participants are from police and judiciary. And also we have to see, the act also says that for implementation of this act and to bring about justice to the child, there has to be a coordinated effort from all the stakeholders. So keeping that in mind, we will move ahead with our presentation again to the next topic, that is issues with regards to procedure and issues of investigation and trial in cases registered under POCSO Act. Now, like we said, that POCSO Act, it is a gender neutral act. It is a gender neutral act. Special, what are the key salient features in this act is that it is a gender neutral act, and it defines wide ranges of sexual offences like penetrative sexual offence, aggravated penetrative sexual offence, sexual harassment, child pornography, etc., which is there in section 3, 5, 7, 9, 11, 13, 14 and 17. If you want me to specify, then okay, section 3, which talks about penetrative sexual assault, like I said, and then 5, aggravated penetrative sexual assault, then aggravated sexual assault, then sexual harassment, then use of child for pornography purpose, and then punishment for using child for pornography purpose, then punishment for storage of pornographic material involving child, and then punishment for abatement. And also there are many other provisions also which I will be dealing later, like if the information, whoever has the information does not report it, then that person will also be penalized. Those are also there. And also, so basically, like I said, it is for the best interest of the child that this act is enacted. So we have to keep in mind throughout while dealing with POCSO cases that the best interest of the child has to be the foremost thing. And then now moving on with investigation. So investigation will start with lodging of FIR. Everybody knows about that. Now under section 19 of the POCSO Act, 19 of the POCSO Act, okay, it says that it is a mandatory provision, and 19 of the POCSO Act says that any information has to be recorded, has to be given before the Special Juvenile Police Unit and the local police unit, who has to record it in writing, and also read the information before to the informant. Okay, and then other So if you see section 19, basically it talks about, I'll just give you a brief gist of it. Like I said, all information, any information which comes, it starts with a non-obstante clause. It says that notwithstanding anything in the CRPC, any information, okay, of child offence, any information regarding the child sexual offence is known to a person or anyone apprehends that such an offence has been committed, then that information is to be given to the Special Juvenile Police Unit or the local police. And that local police or the Special Juvenile Unit is required to make an entry, record it in writing, and then read over the information to the informant, and also make an entry of it in the book which is there with the police. And then another is, if the informant is a child, then it has to be recorded in the language, simple language that the child understands. And if it has to be recorded in a language which is not understandable to the child, then police can always call for a translator or an interpreter who can translate it and make the child understand about it. And then another thing which is required is that police has to immediately provide care and protection to the child if the police feels that the child is in urgent need of the same. And then the police who is receiving the FIR must report the matter within the maximum time of 24 hours, not only to the special court but also to the Child Welfare Committee, CWC. And then if you look at the rules of POCSO Act, so Rule 1 says that the police to whom the information is given has to provide his or name, designation, the address, telephone number, contact details of the officer who supervises the officer receiving the information. And then, like I said, it has to be in a very simple language which child understands. And then copy of the FIR must be given free of cost to the complainant or the parent or guardian if they have come to make the complaint. This is stated in Rule 4.3a. And the police making complaint, I've already told you about it, that the police has to make arrangement for care and protection of the child if the police feels that the need is felt for the care and protection. But for that they have to give the reasons. You have to record the reasons in writing and then give it. And another is, police also should inform about the support services such as counseling, which is provided in Rule 4.3e, and help the child access such services if so required or desired by the child. Then Section 20 is there. This is Section what 19 says, and Rule 4 talks about. And then Section 20, it deals with obligation of media, studio and photographic facility to report cases. So Section 20, what it says that the media or the hotel or the lodge or hospital or club or a studio or any company has to inform the police about coming across any material or object which is sexually exploitive of the child, and non-reporting of same is again punishable under Section 21 of the Act. Then furnishing of false information of lodging a complaint is also made punishable under Section 22. But under Section 22(2), if you see, it says that if a false complaint is made by a child, then no punishment shall be imposed on such child. That is said in Section 22(3). Presentation. POCSO Act, mostly to the police as well as to the judge, throughout it is said that the identity of the child sexually abused cannot be disclosed in any manner unless it is required and with the special permission of the special court, only. Otherwise the identity of the child has to be, cannot be disclosed at all. Then another duty of the police is recording of statement of the child. So this is dealt by Section 24 and Section 26, which talks about additional provisions regarding statement to be recorded. So Section 24 talks about recording of statement of a child by police. 25 is recording of statement of child by magistrate. 26 is additional provisions regarding statement to be recorded. This applies both to the police as well as to the magistrate. So 24, it says that as far as practical, the statement has to be recorded by woman police officer. Woman police officer not below the rank of sub-inspector, and it has to, and that too without uniform. Police officer should not be in uniform, and these are all basically child-friendly approach which the Act is taking. And the other is in the presence, the statement has to be recorded in the presence of parent or any person in whom the child reposes trust, and the statement has to be recorded either in the residence of the child or at any place where he usually resides or a place of his choice, place of choice of the child. And it says that at no point of time the child and the accused should be in contact. Police has to ensure. And there are some instances where we see that in the same vehicle the police will bring the child as well as the accused. There are instances, such instances can arise. So if you please look at the POCSO Act, it says that the child and the accused should not be in contact at all at any point of time. So you all have to take care of that also. And another is that no child shall be detained in police station in night for any reason. And then police officers shall ensure that identity of the child is again protected from public media and all that. It should not be put in the media. And also another important thing is that the statement of the victim is to be recorded through audio and video. And I think this is not done. So the law mandates that it has to be done. Act says that it has to be recorded through audio and video mode. Then comes the recording of the statement should be, like I said, the statement has to be recorded as spoken by the child. This section 26 says, and then the police officer or a magistrate, again 26 says that recording the statement of a child may take assistance of translator, interpreter, having the requisite qualification and experience, and if the child is mentally or physically disabled, then the assistance of special educator or an expert can be taken. And then it informs that the child or guardian or the parents in whom the child has a trust that the child has a right to be assisted and represented by a lawyer of choice. Also the police and the court also has to ensure that if the child is not represented by any lawyer, then the court can engage a legal aid counsel for the child, and police can also make sure that the legal aid counsel is provided to the child, and the right applies before making support. And while recording the statement of the child by the magistrate, it is said that the provision in section 164 of CRPC, which was there, is not applicable in this case, because section 25 of the POCSO Act provides that provided that the provision contained in first proviso of section 1 of section 64 of the court shall, so far as permit the presence of advocate of the accused, shall not be applied in the case in POCSO while recording the statement of the child. And the medical examination of the child is dealt under section 27. So section 27 of the POCSO Act, it says that the medical examination of the child has to be conducted by a woman doctor in accordance with section 164A, which corresponding section is 184 of BNSS, in the presence of parent or any other person on whom the child reposes trust. And whether the FIR is reported or whether the FIR is registered or not, the medical examination of child is a requirement. Medical examination of child has to be done. And then section 52 of the BNSS, it mentions that police can subject the accused to undergo medical examination by a medical practitioner of a government hospital if there is a reasonable ground for believing that the examination of the person will provide evidence as to the commission of an offence. And such report must be submitted by the police, and it should be the part of the final report. And then 193 of the BNS also mandates that police investigation and offence under section 4, 6, 8 or 10 of POCSO Act has to be concluded within 2 months from the date of the registration. This is provided in section 193 of BNSS. So these are the basic requirements which the police needs to understand. And now moving ahead with the judicial provisions under the POCSO for trial. So special court is constituted under 28 of the POCSO Act. It is made for the purpose of speedy trial, and special court also 28 provides 28(3). Okay, 28(3) says that the special court constituted under under section 28, it provides for trying offence under 67B of the Information and Technology Act. This is a special feature under the Act so as to take up the matter pertaining to publication or transmission of sexually explicit materials depicting children in any act or conduct or a manner of facilitating abuse of children online. So section 28 and then special court dealing with child who is sexually abused will take cognizance. This is under section 33, procedure and powers of the special court. So it says that the special court dealing with child who is sexually abused will take cognizance of the offence as there is no procedure. This is not said in the Act that there is no procedure, but it says that may take cognizance of offence without the accused being committed to it for trial upon receiving a complaint of facts which constitute such offence or upon receipt of police report. Then 33 also deals with the manner in which the evidence of the sexually abused child must be recorded. So here it says that while recording the evidence, cross-examination or chief examination or for cross-examination or re-examination, the question to be put to the child has to be communicated to the special court, who will in turn put it before the put to the child. And then frequent breaks can be given to the child during the trial, during the examination of the child. Then create a child-friendly atmosphere, that is section 33, and ensure that the child is not called repeatedly to testify in the trial court, that is 33(5). And then also the court has a duty to ensure that aggressive question or character assassination of child is not permitted, not done, and then so as to ensure the dignity of the child is maintained throughout the trial. So this section 33(6), if you see, it aligns with the direction which is also given in Sakshi Singh or Gurmeet Singh case, which is there. And then identity of the child, like I said before, the identity of the child should not be disclosed during the course of investigation as well as in trial unless the special court permits the disclosure of such identity, that too on the reasons being recorded by the special court. If there is a special reason why the identity has to be disclosed, then only, otherwise it should not be disclosed. Then the special court also has a duty to grant compensation if the court is satisfied that the child needs immediate rehabilitation or it is required for if the child has any mental or physical trauma. Then another is whenever any questions arises with regards to now the determination of age, section 34. It talks about procedure in case of commission of offence by a child and determination of age by the special court. It says that whenever any question arises as to the age of the accused, the special court will have to determine the age of the accused by recording reasons in writing, and such a finding will not become invalid by any subsequent proof that the age of a person as determined by the special court under 34(2) was not correct age of the person. So it gives the power to the special court to determine the age of the person and to record the reason. And section 34(3) says that no order made by special court shall be deemed to be invalid merely by any subsequent proof that the age of the person as determined by it under subsection 2 was not correct age of that person. Then another is section 35, which says that the court has to record the entire evidence of the child within 30 days and the trial has to be completed within 1 year from the date of taking cognizance of the offence. This is what is said in section 35. And then the trial is to be conducted in camera. Again, this is said in Gurmeet Singh case. And the special court, it has the power to take assistance of interpreter, translator while recording the evidence of the child. If the child is mentally challenged or physically or mentally challenged. Then section 20, this is also for the court. It talks about presumption of culpable mental state. So it says that in offence relating to section 3, 5 and 9, the court shall presume that such a person has committed or abetted to commit the offence as the case may be, unless the contrary is proved. And this for this, the accused has the burden to prove it beyond reasonable doubt. But also we have to keep in mind that it is the fundamental duty of the prosecution to establish the age of the victim and also the commission of offence. Then only the presumption will arise under section 20 of the POCSO Act. So these are the procedure which I just discussed, and I hope that everybody understood. Now moving ahead, issues with investigation and trial. So from what I could gather from the limited material that I have, and probably the participants here will be able to elaborate more on the issues. So we welcome that.
Will register a case if it is a case of pregnancy. But if it's not a case of pregnancy, then it's only penetrative sexual assault. Then you will register, not me. You are in a minority. Just 2 of you or 3 of you are seeing. The rest of them are not raising their hands. None of you are talking, not making any statements. I mean, the young mind should be more proactive and thinking than the old people out here, and bringing them all into my fold. It's good that you question it, because then you will think about it. It's important that we think, isn't it? If you think about it, then you will come with a solution. There is not a straightforward answer to the questions. Do I have a solution? No, I do not have a solution.
No, this way is logical. Even if they reserve and not register the case, there will be problem. Better way to be register the case, file the search is up to the court to decide this.
But now let us go a little further. You are absolutely right. And I would also do it if I was a police officer and register a case. Right? But the investigation reveals something completely different. It reveals that the boy was not the perpetrator of the crime. In fact, it was the girl who persuaded the guy to indulge in this activity. And that's the evidence that comes out in your investigation. What will be the result of investigation? What will the charge sheet say? Yes, you said something? Final report. You file a final report of closure. No,
Sanitary report. They're talking about counter FIR.
The counter FIR can't be filed by you.
It can be mandatorily reported.
No, I don't know how you look at it. Okay, this listen to me. When there is a complaint against X, right, in a situation like this, you will register the FIR. That's what you say, because it is making an allegation against the boy, right? So therefore you have no choice but to register it. And you register it. Perfectly justified, no problem. Investigation, however, reveals that it is the girl who has made the boy indulge in this activity. So what will be your charge sheet?
Mistake loss you would have recommended.
No, I'm asking the police officers. I don't want the judicial officers' guidance in this.
We file a closure report.
Because of offence which was alleged was not made out,
Yes.
isn't it? That is what I would have done. I don't know others. কি করুন তাহলে রিপোর্ট পে এফআইআর লজ অন্য অ্যাডভান্স এনি আদার ভিউ
Sir, as he said, sumo tono can we not go for fabricating false information and go for
that is the side tracking. That's lot of things can be done, but that's not the point. The point is what happens to the FIR register. There is no evidence, simple as that. The allegation is something, the material evidence which has come is showing something else. So there's a closure,
With Lordship,
that's all.
that FIR can be closed and
It can't be closed.
that can be closed and
Ah.
finally reported. But under section 19, mandatorily the other offence, the real victim,
What is 19 now?
reporting of offences, mandatory reporting.
Who is to report now?
Anybody who comes across.
But where is the crime?
No.
Which crime?
If upon somebody, like something has been committed, I thought like there was a victim.
No, that's not the point.
So only issue is lawsuit regarding the counter claim now we are now still
Counter claim.
No.
Director companies of law.
counter FIR.
Uh-huh.
Counter FIR has to be put simultaneously. Even if the one
Counter FIR will not be filed by the police officer.
no, they are talking about counter FIR also. And if there is counter FIR,
If the boy wants to file a FIR, then that's his problem. Then they will have to examine it whether it is correct or not. But you are not to guide them. Then you will be their lawyer, not the police officer. So you go to, I think, understand the specific role that we are assigned in this system. A police officer needs to be a police officer. A judge needs to be a judge. Isn't it? We can't take over each other's role. I don't think it will. I think now most of the police officers are very tired and hungry. I think we should stop. Right?
also. And first, what I could find is that issue with regards to investigation and trial first was low representation of women in police forces. Like section 24, it mandates that the evidence is to be recorded by, preferably by, possibly by a woman police officer, but there are many police stations in which there are not many women staff. So because of that also, there are problems, there are challenges which the investigating agencies is facing. I don't know about Sikkim, if you all could tell me whether you all are facing this problem or not. And then lapses in investigation is another which we saw is that, like I said, audio video recording of the statement by the police of the child is also mandatory, but then so far I have not come across any case in which the audio video recording has been submitted by the police, in which the statement is recorded by the police. Okay, and then also this is also one of the major problems, that is the proper infrastructure is not there to ensure that the integrity of electronic evidence is and the chain of custody, how the evidence is to be preserved and all. So these are one of the, I think, most important challenges which the investigating agency is facing. And delay in filing of charges. So delay in filing of charges and commencement of the trial, which can also affect. And this is also because maybe one reason is police are also burdened with work, and also the POCSO court. Though it is a special court, but then the Act does not say that the special court has to specifically deal with such offences only under POCSO Act. So the POCSO courts are also dealing with many other cases. So because of which it is impossible for them to finish the case within 1 year or within the given time as specified. So because of that also the speedy trial, the main purpose of speedy trial is not fulfilled. And then comes the issue of age determination, which we will discuss along with the case law. And also I have written one is over caution in hiding the identity of the child. This I felt was necessary in the sense, why? Because we see, I have come across, I don't know about others, but I'll just talk about myself. I have come across many FIR in POCSO cases wherein the police have been overcautious and have not written the name of the victim only. It is like AXXX, A dash 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 and all. So when that is done, so then we'll not know who the victim is only. So it is completely blank. But Nipun Saxena, if you look at Nipun Saxena case, which I'll be discussing, it nowhere says that in the FIR you cannot write the name. It just says that the documents in which the name of the victims are there should not be put up in a public domain. And also that any documents which contains the name of the victim has to be sealed and put and place it before the court while submitting the charge sheet. But you can make a copy of it by masking the name of the victim, and then you can proceed with the investigation. But it is not, you can give it to anybody, any person who is required, not anybody, but that way. So I'll just read it out to you, all the guidelines which is provided. So non-disclosure of identity of the victim. Nipun Lordship, would you like to come while discussing the case law? Nipun Saxena case has dealt exhaustively with regards to non-disclosure of the identity of the victim. Others, can you put Nipun Saxena case, please? Last para 50. Here the court has also, the judge has also referred to one of the judgment of the Sikkim High Court, that is Subhash Chandra Rai versus State of Sikkim. First I will talk about the guidelines which is given. Para 50 Matsatola. So if we read this, probably it will be very clear what it says. Now the Apex Court, while discussing about the identity of the non-disclosure of identity of the child victim, has issued following directions, certain directions, and the directions are: first is that no person can print or publish in print, electronic, social media, etc. the name of the victim, or even in a remote manner disclose any fact which can lead the victim being identified and which should make her identity known to the public at large. So in public domain you cannot put the name of the victim, you cannot print or publish in through electronic media or through electronic means or social media the name and identity of the victim or anything which will disclose the identity of victim. Second, it says that even if the victim is dead, still you cannot put the name of the victim or give away the identity of the victim in the public domain unless the competent authority or the special court allows you. And then it says that FIR relating to offence under section 376, I am reading it from CRPC because it was before BNSS scheme. So FIR relating to offence under section 376, 376A, 376A, B, 376C, D, DA, DBE of IPC and the offence under POCSO shall not be put in public domain. FIR तपाईले हाल्नु पाउँदैन public domain मा. Okay, relating to such offences 376 rape of years. Then it says in case a victim files an appeal So if a victim files an appeal under section 372, it is not necessary for victim to disclose his or her identity, and the appeal can be dealt with in the manner laid down in the law. So victim, when she files an appeal, it is not necessary that her identity has to be disclosed. Then now, section 55 police officers should keep all the document in which the name of the victim is disclosed as far as possible in a sealed cover and replace. Well, they were just the documents in which the name of the victim is there, which is very important, FIR and all that. It should be kept in a sealed cover and replace these documents by identical documents in which the name of the victim is removed in all records which may be scrutinized in the public domain. Then all the authorities in which the name of the victim is disclosed by the investigating agency, for example, like if you have to send any documents or sample to the RFSL for forensic analysis or to any person or to the doctor and all, then it is then these RFSL or the doctor are duty bound to keep the name and identity of the victim in secret and not disclose it in any manner except in report, which should only be sent in a sealed cover to the investigating agency and to the court. This applies both to the investigating agency and the court when they have to send any documents which has the identity of the victim. Then the person to whom it is sent, to the doctor or to other person, then they also have to ensure that the identity of the victim is not disclosed. Then it says, an application by the next kin to authorize disclosure of identity of dead victim or a victim of unsound mind under section 28A2C of IPC should be made only to the session judge concerned until the government acts under section 22(8)(1)(c) and lays down the criteria as per the direction for identifying such social welfare institution or organization. So this was in section 22(8). 22(8)(a)(1)(c), it says that where the victim is a dead or a minor of unsound mind by or with the authorization and writing to the next kin of the victim. So it says that whoever prints, I'll just read it out to you, it talks about disclosure of identity of victim in certain offences. So whoever prints, publishes name or any matter which may make the identity of a person, identity of any person against whom the offence of rape, 376, 376A, B, C, D is alleged or have to be found to be committed shall be punished with imprisonment of either description for a term which may extend to 2 years and liable to fine when it's then the article section subclause 2 nothing in this section shall extend to any printing or publication of a name or any matter which may make known the identity of victim if such printing or publication is where the victim is dead or minor of unsound mind by or with the authorization in writing of a next kin of a victim, provided that no such authorization shall be given by the next kin to anybody other than the chairman of the secretary by whatever name called for and recognized welfare institution or organization. So in this judgment, the court has said that in what manner it is to be given to the secretary or to the organization, welfare institution is not given in detail at all. So because of that, it says that any application only should be made, any application by the next kin for disclosure of identity under section 22A of IPC should be made only to the special judge concerned until the government comes up with a proper provision as to how the information is to be given and what manner it is to be given, what is to be given. Until they come out with this, it cannot be given to the government or to the welfare organization, but only to the court it can be given. So this is what it is said. And then in case a minor victim under POCSO, disclosure of identity can be permitted only with the permission of the special court, if it is in the interest of the child, that is. Then it says that all the state union territories are requested to set up one-stop center in every district within 1 year. So then the copy of the judgment was given to all, and this guideline is applicable to all of us. So we should ensure that we follow this guideline. Lordship, would you like to say anything in this regard?
We can start the discussion.
Yes, sir.
Continuing with the guidelines that you were speaking.
Yes.
Nipun Saxena, with all respect, I think it's of 2019. Closer home here itself in 2017. If somebody could see the website of the High Court of Sikkim, there is a case called Robin Burman, para 52. The author is right in front of us, Hon'ble Mr. Justice Bhaskar Pradhan. Para 52 discusses all the guidelines that not only the special courts but also the
Yes, status was over.
yes
Party name Robin Burman.
party name of the decades.
Party name Robin Burman.
RABIN BURMAN. All right.
Lordship, this is the same case I think in which we were talking about that masking.
RABIN. All right. You can just write RABIN. All right. Search Robin Burman. I think criminal case 18. Yeah. Go down. End of the page. All right. Go to para 52. I'm skipping others. Others are also important, but para 52 gives the guidelines. And these are the guidelines. I think if you see this, it will all be absolutely clear. Thank you.
Should I read it out? Okay. So, para 52, the direction issued are: 1. All statutory authorities involved in investigation or trial of offence under POCSO Act shall bear in mind that the identity of the child is not only the name of the child but includes the identity of child's family, school, relatives, neighborhood, or any other information by which the identity of the child may be revealed. So, then the number 2, the police officer recording an FIR relating to an alleged offence on child under POCSO Act 2012 shall ensure that the said FIR is not made public or uploaded on public websites or state government websites in compliance with the directives or direction of the Apex Court in the Youth Bar Association of India versus Union of India or any other website. The investigating officer conducting the investigation of an alleged offence on a child under POCSO Act 12 shall ensure that the materials collected during investigation is guarded against disclosure of the identity of a child. Any document or photographs obtained during investigation of case which would contain the identity of child shall not be disclosed to the public media or to any person who is not involved in the administration of criminal justice under the POCSO Act 2012. While issuing copies or certified copies of such documents or photographs as per law to the limited stakeholders under POCSO Act 2012, necessary masking of identity of child shall be ensured before its issuance. The mandate of the Section 23 of POCSO Act 2012 shall be strictly followed. Any person who contravenes the provision of subsection 1 by making any report or present comments on any child from any form of media or studio or photographic facilities without having complete and authentic information which may have the effect of lowering the child's reputation or infringing upon his privacy shall be prosecuted for contravention under Section 23(4) of POCSO Act 2012. Similarly, if any report in any media discloses the identity of child including his name, address, photograph, family details, school, neighborhood or any other particulars which may lead to disclosure of the identity of child, all such person involved in making such report and disclosure shall be prosecuted for contravention thereof under section 23(4) of the POCSO Act 2012. While recording the statement of child as provided under 24 of POCSO Act 2012, police officer shall ensure that the identity of the child is protected from public media unless otherwise directed by the special court in the interest of child. While recording the statement of child under section 24 of POCSO Act 2012, the police officer shall ensure that the identity of the child is not disclosed and for the said purpose may use pseudonyms or any other appropriate way in accordance with law to protect the identity of child. While recording the statement of child by the magistrate under section 25 of the POCSO Act 2012 and in any judicial record thereof, magistrate shall ensure that the identity of the child is not disclosed and necessary precaution is taken to protect the same. Pseudonyms or any other appropriate way in accordance with law shall be adopted to protect the identity of the child. The special court shall ensure that the identity of the child is not disclosed at any time during the course of investigation or trial as mandated under section 33(7) of POCSO Act 2012 unless for reasons to be recorded in writing. The special court is of the opinion that such disclosure is in the interest of the child. Special court is required to ensure that the identity of the child shall not be disclosed anywhere on judicial records and that the name shall be referred by, I'm finding it so difficult to pronounce this, pseudonym or any other appropriate way in accordance with law. For the protection of child's identity as maintained under the POCSO Act 2012, the special court and the investigating officer shall restrict the disclosure of information to limited stakeholders and ensure there is controlled access of non-essential persons during investigation or trial. The special court must ensure the best interests of the child and act as a parent's patriarch for the child. To ensure that the parent's patriarch, how do I explain to the police? To ensure that the identity of the child not disclosed during the course of investigation or trial, the local police or the special juvenile police unit recording the report under section 19, the police officer recording the statement of the child under 24, the investigating officer investigating the offence under POCSO Act 2012, the magistrate recording the statement of child under section 25, the special court conducting the trial of offence under POCSO 2012 shall keep in mind the provisions of section 40 of the POCSO Act which provides, subject to the proviso of section 301 of the Code of Criminal Procedure 1973, the family or the guardian of the child shall be entitled to the assistance of legal counsel of their choice for any offence under this Act, provided that if the family or the guardian of the child are unable to afford a legal counsel, the legal service authority shall provide a lawyer to them. Such lawyer providing assistance of legal counsel to the child shall keep in mind the mandate of law under POCSO Act 2012 which insulates the child's privacy and confidentiality by all means and through all stages of judicial process involving the child. The special public prosecutor who have been appointed by the state government by notification in the official gazette for every special court for conducting cases only under the provisions of POCSO Act 2012 shall also keep in mind the mandate of law under the POCSO Act 2012 which insulates the child's privacy and confidentiality by all means and through all stages of judicial process involving the child. For the proper and effective implementation of POCSO Act 2012, the state government, if not already done, shall prepare guidelines for use of non-governmental organizations, professionals and experts or persons having knowledge of psychology, social work, physical health, mental health and child development to be associated with the pre-trial and trial stage to assist the child as mandated by section 39 of the POCSO Act 2012. The state government shall take effective measures to ensure that the concerned persons, including the police officers, are imparted periodic training on the matters relating to implementation of the provisions of the POCSO Act 2012. As provided for Rule 42F, the Protection of Children from Sexual Offences Rule 2012, The Special Juvenile Police Unit or the local police receiving information under subsection 1 of section 19 of the POCSO Act from any person including the child shall inform the child and his parents or the guardian or other person in whom the child has trust and confidence as to the right of the child to legal advice and counsel and the right to be represented by a lawyer in accordance with section 40 of the POCSO Act 2012. The lawyer so appointed must have sound knowledge of POCSO Act 2012 and sensitivity towards the best interest of a child to ensure that the child's identity is not disclosed amongst other mandate of the POCSO Act 2012. As per the mandate of Rule 4.8 of POCSO Rules 2012, the support person who are assigned by Child Welfare Committee in accordance with Sub-Rule 8 of Rule 4 of the POCSO Rule 2012 to render assistance that the child through the process of investigation and trial or any other person assisting the child in the pre-trial or trial process in respect of any offence under POCSO Act shall at all times maintain confidentiality of all information pertaining to the child to whom he has access. Finally, access. So this is in Robin Burman case, and also in this is 2017 19, and also in Subhash Chandra Rai's case versus State of Sikkim, the Honorable High Court has held that the mandate of the provisions required held that child in conflict with law or child in need of care and protection or child victim or witness of crime involved in the matter, the name, address, school or other particulars which could lead to child being tracked, found and identified shall be disclosed unless for the reasons given in the proviso extracted herein below. So unless only with the permission of the special court and in the best interest of the child, the identity can be disclosed, otherwise it cannot be disclosed. Police and media as well as judiciary are required to be equally sensitive in such matter and ensure that the mandate of the law is complied with to the letters. It is held in Subhash Chandra Rai versus State of Sikkim. And now moving on with issue of age determination. So issue of age determination, this is in 2013. Janal Singh versus State of Haryana, the Supreme Court held that the Rule 12 of JJ Rule 2007, which is strictly actually applicable to a child in conflict with law only with regards to determination of age, should also be the basis for determining the age of a child who is a victim of a crime. Should also be basis for determining the age of a victim child. So then again, this was in 2013, and after the amendment of JJ Act, that is in 2015. Now in P. Yuva Prakash versus State represented by Inspector of Police, this is a judgment of 2023. Supreme Court has said that with reading of section 34, conjointly reading of section 34 of POCSO Act and the 94. So Rule 12 of JJ Act. Now it is in section 94 of the Juvenile Justice Care and Protection Act 2015. So it says that conjoint reading of both this section, it is evident that whenever a dispute with regards to age of a person arises in context of her or him being a victim under POCSO Act, then the court has to take recourse to the steps that is there in section 94 of JJ Act. So section 94 of JJ Act, if we look, 94 of JJ Act. From JJ Act, it says that board or the committee, if it is satisfied that on appearance of the child, on appearance of the individual who is brought before the board, is satisfied that the individual is a child, then you need not go further with the other provisions which is there, that is the determination of age by birth certificate, and then the school record, then birth certificate, and then the other ossification test. The section 94, it talks about presumption of determination of age. So here one says that the committee or a board, based on the appearance of the person who is brought before it, okay, if the committee or the board observes stating the age of the child as nearly as may be and proceeds with inquiry, the case may be without waiting for further confirmation. So here number one, it says that if the board can ascertain that okay, the person is a child, then the board can give a recorded in writing that yes, on the appearance of it, the board is of the view that the child, that the person, the individual is a child. Now then it says that now the section 2 will be applicable only if I'm wrong, please correct me. So section 2 will be applicable only if on the appearance, if you cannot assert, if the board or the committee cannot ascertain that the person is a child, then only the section 2 comes into place. That is, in case the committee or board has a reasonable ground of doubting regarding whether the person brought before it is a child or not, the committee or board, as the case may be, shall undertake the process of the age determination by seeking evidence. By obtaining number one, it says date of birth certificate from the school or matriculation or equivalent certificate from the concerned examination board if available and in absence thereof. Now second is the birth certificate given by corporation or municipal authority or panchayat. Third is in absence of 1 and 2, then the age shall be determined by the ossification test or any latest medical age determination test conducted on order of the committee or the board. Provided that such age determination test conducted on the order of the committee or the board shall be completed within 15 days from the date of such order. Then the age recorded by the committee or the board to be the age so brought before it shall, for the purpose of the act, be deemed to be true age of that person. So same is also applicable to the victim who is brought under the POCSO Act for ascertaining their age. And there's another judgment of Ram Vijay Singh versus State of UP 2021. Here the Supreme Court has held that as per the scheme of the Act, JJ Act it's talking about, when it is obvious to the committee or the board based on the appearance of the person that the said person is a child, the board or the committee shall record the observation stating the age of the child as nearly as may be without waiting for further confirmation of the age. So you don't have to wait for any other proof if the board or the committee is satisfied that from the appearance the person who is brought before is a child. Therefore, the first attempt to determine the age is assessing the physical appearance of a person when brought before the board or the committee. It is only in case of doubt the process of age determination by seeking evidence becomes necessary. Now in XXX versus State of Sikkim, the court has held that the procedure for the board or the committee to follow to determine the age of the person should be followed by the special court. Same which is there in the JJ Act, it also has to be followed in case of the victim of POCSO by the special court. And the court says that insofar as the age of the minor victim is concerned, the best evidence available before the special court is the child produced as a prosecution witness. When a child is brought before the court, that is the best evidence, as a child of 5 years will definitely physically appear so and cannot look like an adult of 18 years of age. It is only in such cases where the court cannot assess the minority of a child victim from her or his physical appearance that it would be difficult for a special court to record observation as required under section 94(1) of JJ. Like I said, 94(1), if from the appearance, if the court is of the view that the individual is a child, then no need to look for other evidence to ascertain that the age or that the individual is a child. But if there is a reasonable doubt that the person is not a child, then the court can go ahead with other provisions that is laid down under section 94(2). Now, while stating this, the court has also kept in regard regarding the investigation agency also, and has said and has observed that we hasten to add that our observation is not to be misunderstood by the prosecution and the investigating agency. It is their primary duty to place before the special court credible and conclusive evidence to establish the age of the victim. It is primary duty of the investigating agency to collect all such evidence that would go to prove the minority of the victim. It is the duty of the prosecution to ensure that evidence collected during investigation by the investigating agency is proved conclusively before the learned special judge. Even if on appearance the victim is a minor child, investigating agencies and the prosecution must ensure all credible evidence must be produced and proved before the special court. From this, what I am trying to say is investigating agency like court has already said that from the appearance, you don't have to look for any other documents. But then, because it is said in this judgment, the court is being cautious that police should not assume, or the investigating agency should not assume that, nani matai liera हामी त हुने रहेछ 5 वर्षको देख्दैछ 2 वर्षको देख्दैछ भयो अरु डकुमेन्ट लिनै पर्दैन भन्ने चाहिँ police cannot think that way, because investigating agency has, it is their duty, the court is saying, to produce all evidence which will establish the age of the victim. So you cannot say that the victim is of 2 years or 5 years, so no need to produce any evidence, because the duty of the investigating agency is to collect and produce all credible evidence which will establish their case, the age of the victim basically. So you have to keep that in mind.
Just to change the format and let's be more interactive. I want you all to discuss issues pertaining to your investigation. I want you all to discuss issues pertaining to the trial with the judges out here. And let's take it forward. First, with the investigation, I would want you to tell us how you investigate a POCSO case. Just give a brief outline as to the investigation. This is not to test you, it is to understand how it works. Okay? So you can be comfortable, you can sit down and do it, you can go there and do it, whatever you feel.
Good afternoon everyone. Recently, since I've been transferred in SJA Hon'ble since May, so before this I was in CID and this HDGP office, and after that DG office. So we have seen, after I joined this as SJP Hon'ble, I have seen the registration of 2 cases under POCSO Act. So right after the registration of the cases, POCSO, the medical examination of the victim is done. Victim, if the accused is there, so we forward the accused as well for the medical examination and the preservation of this crime scene. So after the implementation of this BNS is the new criminal laws, 3 criminal laws. So IUs, so they have to record. So usually what they do in the field, they record seizure and recording of all this crime scene is done through the app called eSaksha app. So in both the cases we have recorded audio as well as we have done the audio as well as video recording of the crime scene. Crime scene we have done through this eSaksha app, but recording of the statement of the victim in the presence of, that's been made a mandatory to the notification issued by our the department only. So it has to be done in the presence of the subdivision police officer. So I was there in both the cases. So we have done the recording of the victim's statement through this audio as well as video. Through that is only through the app only, the eSaksha app. So after, but we have one question also. In both the cases, one victim she's 5 years old only, and accused is the neighbor who is a dropout. But the problem here, I wanted to ask this question. They are actually living in this government that's a dilapidated, which is totally in a dilapidated condition. So they are staying in that this kacha type of house. So when it comes to the issue of this birth certificate, he had procured this birth certificate from this Nepal. So it is not possible for the IO to visit Nepal because that is issue from the Nepal only. So in this case, actually I had directed the IO to submit the requisitions to the court saying the ossification is necessary, though it is mentioned that as per the document which was provided to the IO by the guardian of the accused, he is also juvenile. He is just 16 years. But the documents says 16 years, appearance wise also. And the IU is also present here. This case was registered in Hon'ble. So I would like to ask, in fact, request the IU of the case to share the problem which he faced, especially regarding this ossification. We had requested for the ossification of the test. So Vicky, if you can share.
Ossification, good afternoon everyone. The ossification test was not granted to me.
Okay. Why was it not granted? That was very abrupt. Why wasn't it granted?
So firstly I was requested to produce the school register.
So therefore,
Then I submitted the school register.
then
So ossification test was not done
why was it so then?
because order was not given to me.
No. Okay. Yeah.
In fact, the requisition was made to the board only, the JJB only, but instead of asking them to produce, he was totally denied.
Is this a pending case?
It's a recent case, Your Lordship.
Recent case.
You are still investigating it.
Yes, sir.
So anything we say will be an advice to you. And if the advice is wrong, maybe you will misunderstand that. So it may not be possible for us to give opinion on pending cases. But in general, we can talk about it. Right? In pending cases, if you take an opinion, it could be a good opinion, it could be a terrible opinion of judges. Right? We are capable of both. So you should be understanding very clearly that at the stage of investigation, it is your job. You got to understand it well. You got to understand the law well. Investigate to the best of your ability and produce your evidence. Right? Now, please sit down, please sit down.
Yes.
You talked about a problem with regard to the age of the accused,
Juvenile.
the juvenile. So the accused was a juvenile.
Juvenile.
Okay. Now, what does the Juvenile Justice Act say about age determination?
Number one is physical appearance, then
Birth certificate, this is where
No.
the problem lies because
No, we will come to the birth certificate in a while. You're talking about the juvenile justice. Just what you need to really understand and do is focus on the law, right? You have a problem. The problem is determination of an age of an accused who is a juvenile. So you have to look for the Juvenile Justice Act. Now go to Juvenile Justice Act and see 94, right? Now what is it that you are required to do, right? 94(1) talks about the board. You have to take the person to the board, right?
but I think in this case, he had done
No,
the-
don't go back to the case
Yeah.
because I will not be able to give you any guidance. Okay, this is not an advice to you on the case. So please understand very clearly, both Mr. Vicky and as well as you, that we are not guiding you in the investigation of that particular case. We are talking about an accused person who is produced before you. The issue was Nepal. The issue could be any other foreign country. A foreign person who has come into Sikkim in which you are investigating a crime committed by him. In that case, we are trying him under the Indian laws, isn't it? If you are trying him under the Indian laws, the Juvenile Justice Act comes into play, right? Juvenile Justice Act talks about 94(1) talks about the board looking at the person, right? And seeing from the appearance whether he is a juvenile or not. If he is a 7-year-old, it will be very easy for anybody to come to a conclusion, right? But if he is 16 or sometime even 15 or above, and you cannot come to any determination by physical appearance of that particular person, then you have to get certain documents, right? Now let us look at the documents which they are asking for. Let me go to number 1. What is that? Please read it. The police officers can read it.
where it is obvious to the committee of the board, based on the
That is
appearance,
94(1). Right?
based on the appearance of the person brought before it under any of the provisions of this act, other than for the purpose of giving evidence that the said person is a child, the committee or the board shall record such observations taking the age of the child as nearly as may be and proceed with the inquiry under section 14 or section 36 as the case may be without waiting for further confirmation of the age.
Okay, let's pause here for a moment. Does it make any distinction between a Nepalese citizen or an American citizen and an Indian citizen? It does not. Appearance of a person, you can examine. The board can do that, right? Now come to the next one.
In case the committee or the board has reasonable grounds for doubt regarding whether the person brought before it as a child or not, the committee or the board, as the case may be, shall undertake the process of age determination by seeking evidence by obtaining the date of birth certificate from the school or the matriculation or equivalent certificate from the concerned examination board, if available, and in the absence thereof.
No, just stop there for a moment. The first requirement under 19.4, what is that?
Date of birth.
No, what is that?
That is.
Which is a subsection? 2. I am not reading it myself because I know it, but I want you all to read it. Therefore I am asking you. Sorry for this indulgence. But it is 94.2, right? It is talking about what?
Birth certificate.
Birth certificate. Does it say from India?
Oh no.
So why are you reading India there? Does it say America? It doesn't talk about it. It says a certificate of a school. Right? So why are we reading into the law? The focus is the determination of the age of the child. Does that answer your question? Yes. Now, investigation of cases which travels beyond the jurisdiction of your thing. The relevant law provides for that. You will have to look for that provision where you can stretch your investigation. In many cases, you know the police has jurisdiction within the state, right? But every day, each one of you are investigating cases which are traveling to Siliguri, Kalimpong, Darjeeling, which is beyond the jurisdiction. How are you doing that? It must be under a law, right? So that way you can do it. It can travel beyond. You have to look for the provision in the law to enable you to stretch that investigation. Maybe you will need assistance from the police from the other side, right? But the provisions will be there. You will have to look for it. Does that help you? I can't give you specific answers. You will have to look for it. Unless you put in your head, and I am sure all of you are very smart, I can see it, right? But you got to look at the law. If you do not read the law, you will not find answers. Now if you read it, see the problem is, have you done legal training? Do you have a law background? That's right. But you are still as smart as I am in law. I mean, not otherwise, right? Right? So you have the capacity and the capability to understand the law. It's just that how we look at it, we have been trained like this for 3 decades. So therefore we read law in a different way. Now you need to get into that mind of ours. Right? Now if you look at it, does that make it clear to you?
Yes, Lordship.
So this is how you have to look at it, okay? What is the law saying? Search for that. Is a certificate of, the question to you is, if a certificate of birth, okay, is obtained from Nepal or US, that certificate of birth will be under their law, correct? If it is authentic in that country and it is a document by which in that country it can be established beyond doubt that the age of that particular person is that in that country, what is the difficulty in accepting it here? Under 94.2.
No way it's mentioned like that.
So you can argue it before the judges and let's see what the judges have to say. I'm just giving you
Usually the IU can speak also, please, on behalf. Usually, especially within the India, we have no issues in traveling. But when it comes to Nepal,
Yes.
But the problem would be, suppose if you get birth certificate from Nepal or even school certificate from Nepal, then the step where you have to authenticate that document probably could become a problem for the IOs.
Problems are always there. Problems have to be resolved, isn't it? Problems can't be your concern. You have to resolve problems. That's why you are there. Why is an investigation necessary? To resolve problems. If you keep on putting this problem as a thing, is an impediment for your investigation, then you will never investigate. Then you can sit down in your desk and write your charge sheet. You don't have to go to the place of occurrence, do you? Somebody will come and tell you your story anyway. I've seen a number of what you call tabletop charge sheets with no investigation. In my career, I'm not talking about Sikkim, but I've traveled beyond Sikkim and I've seen investigation which has happened in the desk right throughout. It's just been there on the desk for about 90 days, and then there is a charge sheet. But that's your job to investigate. What does investigation mean to you?
I was just asking them if they have to procure a witness, suppose a government officer to prove the document or birth certificate, then they have something to say.
Who? The judge has something to say or the police has something to say?
Ma'am, what we were discussing is, like when we have to authenticate the document, then supposing if we have to go to Nepal, then the process, we have to push our file through the DGP, through the Home Department, through the Ministry of External Affairs. So there's a delay. It is not that they will not grant, but a delay change.
So when there is a delay, what is the process that you follow? Under the, what is the new law? After CRPC, what is it? BNS. What is the law? There is a time period provided for every investigation to complete, isn't it?
Yes, sir.
90 days for murder, let us say.
Yes.
Right? But many times you take beyond that.
Yes.
So how do you extend that period?
We intimate to the learned court seeking for more time.
And supplementary.
And then maybe
And
later.
if you convince the learned court that you need more time for a situation like this, do you think the learned judges will deny you that time? The judges can answer that. Will you deny that time?
What she's saying is that probably a supplementary charge sheet would suffice. I mean, would help in that course. And as a court, I don't think so we would deny that.
So that answers your problem.
Let's say in case of child in conflict with law, he has to prove that he is child in conflict with law. In case of that, police may ask him to produce the document.
Whatever is required. That's right. Investigation is always an amazing experience, as I see, because I've seen a number of investigations, and sometimes I wish I was a police officer. I really wish, in many a times, because it excites me the way you all have to unearth the truth. I find it very, very exciting, and we as judges have this added advantage, that we see everything after you complete it. So we are very, open to criticizing your investigation. That is how we do it. But it happened to me when I was practicing in the Supreme Court. Every trial court judgment which came to be examined by the Supreme Court, when we looked at it in appeal, we were critical of. You question gareko bhai chahi aba khatam hune थियो. And then I got back here. My journey was reverse, and I came back to Sikkim, and then I entered the trial court. When I entered the trial court, I was a novice. All of them judges, they were up there, and asking a question itself was difficult. Forget asking that particular relevant question. We completely forgot what is the question to be asked. The situation was different. Sometimes I remember a particular case in which a witness acted as if he was the judge. When I asked the question, the answer he gave to me was, "It is not a fact." I didn't know how to react to that. You see, my question stopped. So these are challenges you face during trial, and the same thing in investigation. It is only when I realized, when I entered the trial court, that I realized the issues that all of you suffer from. Because you have to be on your toes all the time, and therefore it is very important to be alert about the law. It's very, very important for you to be. So I would urge each one of you to try and find time to understand the law better. How the law plays out, how the Evidence Act plays out. You see, we need to bridge that gap between the investigation and the trial. If you do that, then you will definitely reach your goals. That's what I feel, right? Okay, yeah, continue please.
The births will be given by a corporation or a municipal authority or a panchayat, and only in the absence of 1 and 2 above, age shall be determined by an ossification test or any other latest medical age determination test conducted on the orders of the committee or the board.
Correct. So that what Mr. Vicky pointed out, when you ask for ossification test, the judge told you get the number 1 and number 2 document. Basically, was the judge wrong in doing that? That's how law works out. You see, if you just don't look at the law as AM or the DNA, that really can't be your stand. You have to ensure that you investigate the case properly and produce all such evidence which are credible to the court so that it is examined properly to unearth the truth. That's very important.
Just an informal question I wanted to ask the IO. Whether any application was made as a matter for such training? Because I confirmed with my staff just now the application.
No, I don't want this debate to go in the courtrooms now. So forget all this, right? Therefore, I was hesitant to answer these questions. Do not ask questions pertaining to pending cases. You'll have these multiple problems, right? And whatever we discussed here is with a rider. It is not our opinion that we are giving. It is just trying to guide you on the right path. Okay? Yes, please continue. No, this we have seen. We have seen this. So I was just giving you a general idea of how to examine the law, how to look at the law. And if you understand how the mind of a judge works, then maybe it will be easier for you to understand how to place the evidence. That's what so I'm disclosing my mind so that you place it correctly. Let's continue please. But I am more interested in how you investigate a case.
So,
a POCSO case.
POCSO, all this, after this medical formalities, arrest is done. And the crime scene, as per the mandate of this new criminal law, so it is.
Can I just interject here for a moment? Earlier, you talked about the audio video recording of the victim's statement. Now, when you do that, what do you do with that?
We have a SJA app. That is usually for the seizure and the recording of the entire seizure procedure is done through that app only. So sometimes there's a technical, because of the technical, recently we have faced this technical issue in this, especially when it comes to this SJA app. So the IO has recorded, the Prashant, Mr. Mangan. So
no, don't go back to the case.
No, because recently this has been in court with your lordship. So
SJA app.
SJA app.
That is a government of India?
Yeah, that's NIC.
Okay.
Okay. So it is done through that app also. So apart from that,
so how you record it with some instrument? Is it?
That is already installed. You have to install to the app. That's
where on your phone?
That's Play Store.
I'm a novice in this. on your mobile phones, is it? Yes.
So good afternoon.
Good afternoon.
So with regard to search and seizure, after the implementation of BNSS, what we have started doing is, by the time we do a search and seizure, we do it in a audio video manner, and immediately after the search and seizure is completed, within 24 hours we send a copy to the magistrate along with the videograph and the later citing that the audio video was done in connection with this case.
So how do you send that? What is it that you send physically to the magistrate?
We send, we store the data in a pen drive or a CD, whatever is available, and we send it to the magistrate. And when it comes
so how quickly do you send it?
So we do as early as possible, sir.
How is that? Give me a time frame.
So 24 hours.
Within 24 hours, the moment an audio video recording is done of the victim's statement, that you transfer it from your phone into a pen drive and then send that with a covering note to the magistrate.
Sir.
That's how you do it.
So not only victim statement, but the search and seizure procedure. So search and seizure procedure.
What is that?
So if we search, if you go through a crime scene, and search section 105 mandates that we have to submit the search and seizure evidence without unnecessary delay. So whenever we go to a crime scene, we do the search and seizure through, since every SHO, every police station is provided with a phone, official phone. Every police station is provided, so we do the recording through that phone only, sir. And there is an app, just ma'am mentioned, it's called eSaksha app. It's a NIC developed app, and every police station, every IO is directed to install the app in their phone, respective phone, and we do the recording simultaneously through that app also, sir. So that is the practice we do for now, sir.
Okay. So let me play the devil's advocate to you. Right. I'm not a judge anymore. Let me be the defense lawyer. And if you were the investigating officer and you follow this procedure, and I ask you, this pen drive which you have submitted to the court is only secondary evidence. Where is the primary evidence? What will be your answer?
It's on the phone only.
Where is the phone?
It's with the IO.
Has the IO used this phone over this period? No.
They use it.
He's used
They
it.
use it, yes.
I make an allegation that therefore the evidence has been tampered.
No.
How do you say that?
This is particular because the official phone which has been issued to the IO as well to all the officers, especially
That's right, it's an official phone, but he's using it.
He's using it. That's
He uses
the
it, only
CUC
tampered
number.
with it.
We have this CUC number particularly allotted to the particular SHOs. So it's been,
That's all right. Now he has recorded in his thing, right? He's recorded it from his mobile phone. Isn't that the primary evidence?
that is the primary.
But he's using it. So you are now tampering with primary evidence.
No, we have the way this the app is being developed. I think the IO can because I'm also not much
Okay.
with this IO.
Okay.
I mean this app, this familiarity.
Once the video is recorded on the mobile phone, we save it on a computer, sir. And then when we make a copy of it, we create a hash value. So later on during the trial, the hash value can become with by the search system.
So you
Yes, and we also issue a certificate on the section 63 4C present, sir. So we are recording the crime scene videos through
that is as required under the act?
Yes, SJA, yeah, but I'm not sure whether the courts are aware of it now. We have been mandated to do so by our departments, but we are not aware whether the courts are using it. It is supposed to be linked to the ICGS system, sir, and that's how the SJA videos are supposed to work in future. Once we click the videos through our phone, It is supposed to get uploaded and then it is supposed to get synced to the court system so that we don't have to transfer the files through phones or CDs or pen drives. So the courts can look at the old system in the court itself. That's how it's supposed to work.
I think
so. The IO will give the system to the court.
Are we doing that?
Umesh.
By using this phone.
Yes,
because we have to
Umesh,
keep in tandem with
that's
the
true
law.
in the NIC ko server pa nahi na? NIC ko server.
Not sure.
No, I can't be public. It's a NIC. Okay. Yes.
When it comes to the use of a digital device to collect electronic evidence like photographs and videographs, in one or two cases before me, a crime scene photographer was used, and then he came to the dock to basically depose, and he was the one who gave the 65B certificate. So he actually had his own device, his own desk, his own everything. So why doesn't the police department, other departments follow that? He was actually...
No, but they are saying that it is required under the law to do it in that particular manner. Each of them has been provided with a mobile phone with which they connect to the e-Sakshi and they connect and give the evidence out there in the e-Sakshi. That's the requirement of the law.
But
so why
from
should
the court
they follow
side,
the law?
we are from the court side, we have not received anything of that sort.
Now they are doing it, and when the charge sheets are come, then you will see this is a transitional period, so you will have to
Actually, as per the law, now it has become mandatory that it has to be audio and every search and seizure.
Correct.
This has to be audio as well video recorded. So just to facilitate the IOs of the case, so NIC has developed this e-Sakshi app. That is the purpose of the development of this e-Sakshi app.
Fantastic. We need to work with the system. It's important that we do that. Just that, you need to be a little, I was trying to be a devil's advocate for you to be a little cautious about doing these things, Make sure that you are guarded against all these problems. Defense lawyer can be as terrible as I am, and maybe some might be worse. So they will question you for every step that you take. So you must have valid legal answers to meet those challenges. Right? So there is a requirement of a 65B certificate. So you make sure that you have that, isn't it? These are guards which you must have. If you do not have these guards, then your entire line of investigation will fall because of these few little flaws. That's a word of caution. Yes, then?
The search and seizure that is done through that app.
So therefore it is all videographed. So I take it that in every case, criminal case, search and seizure is done
to the e-Sakshi app.
So what she flagged earlier, that's not an issue anymore. Right. Please go ahead.
As mentioned, the information is given to the magistrate regarding the restriction of the offence also, and as well as to the CWC also. And if the victim desired, or as mentioned in the law itself, that the counseling session, it is usually given, that is through the help of the social welfare department. And I have one issue here I had raised, that is, I have one issue in my mind, especially when it comes to this probation officer from this welfare department. Usually what happened, we have seen the victim of this POCSO cases, it's from the very economically weaker section only. So it's and it is always a known, the accused person is always a known person. And there's a practice of especially when it comes to juvenile. So at later stage, that's my question, Your Lordship. So at later stage, if the juvenile is released on bail, and once the IOs, the charge sheet is filed, usually, I'm not supposed to say all this, but the practice is here, we don't follow, because it's not possible for the IOs to follow each and every case also. That is not possible also. Sometimes the translation, sometimes the other issues cropped up. So once this accused is enlarged on bail, so there's every possibility that the accused comes in contact with the victim. So usually it's a known person. So there is at the same time the sensitivity and what do you call say that? It is the accused is sometimes related to the victim also. So in such cases, how do we like ensure that usually it's not IO who like monitor the movement of the once it is enlarged on bail. So once it is enlarged on bail, how do we ensure that the accused doesn't come in contact with the victim, because in most of the cases we have seen the such thing has occurred. So any direction to the probation officers from the...
You can address this.
Because I don't think we have ever seen like any probation officers. Chambu, what do you have to say? So any probation officers, they like monitoring the movement of the...
Yeah, you've raised in fact two issues. So let the judge react to that. No, then we'll go for
I
it.
agree that a probation officer is very important.
Yes, yes. So how do you address these two issues which she's talking about? The victim and the accused are known to each other, and when the accused is enlarged on bail, there is every possibility that they are going to be interacting, and therefore
these situations arise once the accused is released on bail. Now perhaps what you were trying to say is, until the investigation or until the trial is complete, the person should not be released on bail. Perhaps that is one meaning which I get, but the law is that until the trial is over and the person is proven to be guilty, he is presumed to be innocent. So what does the court do is, given the circumstances, the merit of each case, even at the stage of investigation or even at the stage of trial, the person can be released on bail, which is normally done, but with conditions. Now there are always conditions whenever a person is released on bail, and I am sure that all the judicial officers here will impose one condition, which is that in case the victim and the accused they reside in the same locality, he will not meet the victim. Number one, not induce the victim's family or threaten any of the witnesses. These are some of the basic conditions. Now I agree that the IO is transferred from that particular police station to some other police station, and he is no longer associated with this case at all because it is already on trial. Now under such circumstances, these conditions which is already there has to be seen by at least some people in that particular police station. And if you know, like you have said that you have come to know that these people are meeting the victim and they are inducing the victim's family. Now if you know, you can always inform the court, because these conditions, if violated, will result in cancellation of bail. So what you can do is, once you know that any of these conditions are violated, especially if there is inducement or threat, then your duty or anybody else of that police station would be to inform the court, move an application through the PP and ask for cancellation of bail. And that is the only solution that I see. If any of my brothers and sisters here would like to add, please do so.
Let me just elaborate on this aspect, and it's a very important issue that you've raised. I have seen certain things in this journey of mine. We have, applications filed by the investigating officer for rejection of bail, and sometimes we have seen public prosecutors coming to the court and saying that can be released, but it's an oral kind of thing. But the investigating officer
must ensure that the public prosecutor who is before the court in a bail case is briefed with regard to the special relationship which you are talking about, the special circumstances. The very fact that you are aware of the circumstance is because of your investigation. In your investigation, you have found that the victim and the accused are known to each other. They are either staying in the same locality or they are staying in the same household. Many a time it is the same house, sometimes a relative, isn't it? Now it is your duty primarily to ensure that this is pointed out and special conditions are informed to the court. You have to tell the court that because of this situation, there are certain conditions which needs to be imposed and request for that. The moment you do that, the moment you said it, I wouldn't wink an eyelid before I impose that condition because it's a very important factor. But it is for you to inform it. Now, you have a problem there. The investigation is done by you, and before you complete the investigation, it is transferred to somebody else, and somebody else is taken over. Don't you have this system where you brief the new investigating officer?
Usually, especially such cases, we usually don't transfer. So it's
No, you said there is the issue.
So yeah, I said like after the submission of the charge sheet. So that is not possible for the IO to monitor each and every case. So what is happening in the court, how the trial is taking place.
What is the role of an investigating officer after the filing of the charge sheet under the law?
Actually, supposed to.
Then that's your job, isn't it? You can't say I can't. That's not my job. You need to monitor it during the trial through the public prosecutor. That's your job, isn't it?
Lordship, the question is like, has there been instances where the court itself has directed the probation officer in such similar, the POCSO case especially, has there been any instances where the probation officer, because the role of the probation officer comes.
What is the role of a probation officer?
So he has to monitor, especially when it comes to POCSO, especially the
Can we read it? What? Here is the POCSO Act. What are you talking about?
Juvenile justice.
You're reading about the Juvenile Justice Act? We have the Juvenile Justice Act. You are important to Juvenile Justice. Yes, please, of course.
Yes. With the lordship kind permission, I am to just add what our principal district and session judge has just sounded our officer present here. The problem issue is now, after getting bail, there is every possibility of having contact with victim and manipulating the evidence already collected by the IOT case. So I read somewhere, IOT case can play a very active role. IOT case, if there is chances of having that particular atmosphere, IOT case can change the identity of the victim, change the SIM number, and most of the time, most of the victim in POCSO Act, they will be, even after completion of the trial, in the shelter home. The shelter home is now being run by the government. Government authorities there, like what Madam says, probation officer is there. Always keep in touch, put eye on the movement of the accused, because there are some conditions already put by the council court not to keep in touch with the accused. That would be the violation of the bail condition. So there are, I think, I am not able to recollect, but there are already guidelines, SOP given by the Government of India and respective states, how to protect the victim even after, not to talk about during the trial. During the trial that SOP is already there. And after completion of the trial also, what are the innovative steps required to be taken by IO of the case to protect the victim so that she can comfortably come before the court and depose for getting justice by the victim. So I am to request if I am not able to trace out the guidelines, I will definitely share, of course, with the permission of His Lordship. And not to strictly confined to the procedure, the case is required to play innovative ideas, proactive ideas, and protect the identity of the victim. I read somewhere, in that particular case, scene was changed, location of the victim was changed until completion of the trial. And she went and deposed very comfortably, and there was no tampering of evidence I have seen so far. Thank you.
Including protecting the victims. The Supreme Court has given in one judgment, and we will pass it on to you, certain directions to the central government to frame the victim protection scheme. I am not aware whether that has been done, but in the meantime, before that scheme is in place, the Supreme Court itself has given a very detailed guidelines as to how to protect victims. Each one of you must have that. When you are basically investigating the case, it is your duty to ensure that the victim is protected. The witnesses are protected. Victim also is a witness, right? So therefore, it is important for you to be guided by that. And more than that, forget the guidelines, forget the law, forget. It is your primary duty. You are now the guardian of the victim. You've taken over the role of ensuring that she gets justice, isn't it? Now, if anything that comes on the way is going to hamper the justice to be given to the victim, then you need to guard it. That's why you are a police officer. So if you take it upon yourself, then you will definitely be innovative. You will devise methods to ensure that the witnesses are well protected. In one instance, I remember, I had to give directions with regard to the protection of that victim, right? And I directed the IO to ensure that the victim does not come in contact with any of the accused person who I had to release on bail. You understand? And certain protective orders were passed to that. But that is the job which you have to do. You have to ensure that, so if you are the investigating officer and you think there is a special circumstance, you will have to first, if it is a bail order, make sure that those conditions are imposed. But that should not, deter you, or you think that that's the end of the thing. You will have to ensure that even after that, you are protecting the victim or the witnesses all the time. So maybe you should get direction from your senior officer or anybody who will place a vigilance of that particular area. Maybe a police officer assigned to ensure that this does not happen. Maybe cameras installed. You have to devise methods to ensure that protection happens. But you will have to do that because that's your primary role. If we start thinking that this is the end of our role, I have filed my charge sheet and that's the end of it. I have opposed the bail, but the court has granted bail. So there is nothing I can do about it. Then I feel that would be abandonment of your responsibility. So it is your duty and you have to ensure that you fulfill that with all your might. Yes?
I just want sir, I want to request once, because we attended one training about a few months ago regarding this child rights only. So what we were told is once we complete our investigation with regard to the victim, after all our investigation is complete, then we forward the victim to the CWC. Once we place the victim before the Child Welfare Board, then what they normally do is either they send it along with the guardians or put up in a shelter home. So now regarding what ma'am was talking about, the follow-up things, so what I want to
It's all right, please sit down, it's all right.
so what I want to pray the learned court is that a strict SOP to be also forwarded to the CWC, that once a victim has come to them, it is also their duty to keep a follow-up. Because so what happened is, when I was posted in Rangpur, there was a POCSO case which trial, everything happened, it was after 1 year, then I somehow got in touch with the victim because it was related to compensation. Even though compensation part is not our job, it is the DALSA who does it. So when I got in contact with the victim, I was amazed, I was kind of disheartened to find that she wanted to continue with her studies, but she was staying at home. Then when I tried to speak with the victim, what was the problem, then she said all her problems. She wants to go to school, but she don't want to go to that particular school because the accused is also there. That's when I called up the DCPU of the particular district. I said, Madam, please send your outreach workers because this is the case. Then the district, the child workers, outreach workers, we call them, they came. Then I told them, please put her to a different school. She can always join, though 1 year already gap, she already had to take 1 year gap. But then I told her, now currently she's studying somewhere in Gangtok school. So this, because like ma'am said, so once I'm posted out of one district, another district, we usually tend to forget because then again we are overburdened with the cases in other jurisdictions. So that was one particular case where I even spoke to the DCPU probation officer. I said, Madam, once we place the child before the CWC, follow up what is happening with the victim. So in this case, I myself took 3 days. I convinced the guardians. So sometimes we even, as a police officer, I'm not trying to show off, but we even pay for their vehicle expenses, transport expenses. Then I called the outreach workers. I spoke to the DCPU. Finally, she was taken out from that village. Now, because she was quite bright child, sir, because she was able to converse very fluently in English, Nepali. So I also felt that she needs education. I said, why are you not doing it? Because Madam, this school ma goyo pani tya sabai le pura garcha. So that's where the DCPU, Child Welfare Commission, they should have also taken little bit of effort. That is what. So if
so, what you're really trying to say, and I think this is a very important point that you raised. I think the stakeholders of this criminal justice system should work in tandem with each other. I think that should be an exercise which we can take. Right? We can have another training session with all of them, and we can have a discussion. In the first instance, when when it was pointed out to me that the judicial officers and the police officers are being grouped together to have a discussion, I was a little skeptical because my understanding is, although both of us are searching for the truth, the approach has to be different. So I should not be addressing the judicial officer and misguiding you, or I should not be addressing you and misguiding the judge. And I thought, and yesterday I spent almost 2-3 hours with the deputy director to ensure that both of us are in tandem in our expressing our thought process, that we don't confuse the two situations. But now with this kind of discussion, I think maybe another session with yes, I think it will be important that we have, and we will take note of that and we will ensure that we have it. But what is happening, and this is something which you need to urge to your superior officers, and I talked about it also to your superior officers. We have a number of training. You don't have an academy. You should demand an academy. Firstly, right? You don't have an academy. I don't know how many times you go for training outside. Your institutes are not academies where you are learning the law, right? We are providing you, legal training, but after that, the people who are trained are not investigating the cases. They are doing some other duty. So, the resources which are already limited with you all is being, not used properly. That's what I feel. And there has to be some kind of a continuity with regard to these issues. Because a good trained, sensitive police officer investigating a particular subject would be very important. They're a novice police officer. So you have to, I don't know how you do it, but I think you should be, when you have this interaction with your superior officers, you will have to bring these issues to light and bring it out. I have discussed it with all your senior police officers about this.
Your Lordship, I'll bring before the notice of
But this is very, very important. Training is important. All of us undergo training.
You know, the number of times we said, I mean, I've spent 3 decades, I think I should know the law, everything. But then I don't, you know. I am sent for training to the academy, I am going there, all of them are attending training. The training process has to be continuous. We have to be, now they are talking about certain laws which I am not aware of. Now if I don't undergo training, somewhere there will be a gap between what you all are saying and what I am thinking. You know, and that should not be there. So continuous training, continuous learning is very, very important. Now, I don't know, on the last occasion, how many of you had attended the last session? All of you are new faces, isn't it? I don't see a single officer who went through the SADA and the, what they call NDPS training here today.
No,
they're not there. Why is it? Was it a format? New people to be trained?
because this choice of the concerned operating police department.
So how was the choice taken?
They have some sort of guidelines that based on the recorded number of cases being played by each police officer.
So it's the guideline, I mean whatever, that's an internal matter. But if you are going to be trained as special police officer to investigate POCSO cases, I'm very happy. I'm very happy. Right. But, you know, if after this you vanish into some other camps and do something else, then what is the purpose of these interactions? You see, you need to utilize these exchanges and communication that we are having so that we become more effective in our dispensation of justice, isn't it?
So for today's session, we all have IOs who will be investigating the cases, except for that in the last one. Otherwise, all of them are IOs.
Okay. So, you know, the FIR, the first thing which you, before the investigation, there are instances where I have noticed that in the FIR, we are talking about, in the earlier session, we talk about disclosure of identity of the victim. I have seen FIR in the original which does not have the name of the victim. That's the overcautious approach which the deputy was mentioning about. So let us focus a little on the word which is used in section 33(7) of the POCSO Act.
Sir, should we avoid, sorry, should we avoid masking the name in the FIR?
I'm coming to that. That's right. This is an issue which is with you, because when there is a judgment which comes from the court, you are overcautious, isn't it? Now that is exactly what is happening, and I have seen number of FIRs which does not have the name of the victim. The victim is XXX. In one instance, in appeal, by the defense lawyer, the argument made to me was, there is no victim. Who is the victim? None of the document discloses who is the victim, because it is only XXX, and I don't see any XXX around. So therefore, acquit me. You understand the gravity of this situation. So when we need to do a little bit of focusing, the word used is disclosure. Just think about it, the word is disclosure. Right? So if I were to ask you, what is your name? Do you have a name? Can you completely obliterate the name? Can you be a lady with no name? You cannot. You do not disclose it means don't disclose it. Reveal never know. Masking means masking like this. But when I take out the mask, the name should be there. That is non-disclosure. But if you take this document and take your pen or your whitener and completely destroy it, is that masking? What is that? Erasing. That is eradicating the existence of that person, isn't it? So you cannot have this overcautious approach, as she pointed out. The name should be there, but it should not be revealed. FIR ma naam to hunu paryo, right? But when you give it out in the public domain, now how will you give it out in the public domain? Tell me. An FIR is a public document, isn't it? Somebody may apply for a copy for it, right? When you give that copy out, then you have no control over it. You are directed under 33(7) not to disclose it. So you will mask it. But you will not obliterate it. You will not destroy evidence. I have seen in one case, and let me be very frank with you, I have seen in one case that the entire records in the original was destroyed by using pen, red in color, and scratching out the name of the victim in every document, starting from FIR, from medical records, from birth certificates, and everything that is there. If therefore the defense lawyer is to argue that the victim does not exist, he is absolutely right. Do you understand the gravity of the situation? So this overcautious approach, please abandon it. Understand the meaning of the word disclosure, right? Doesn't mean that non-mention. You can't have a FIR of the victim as XXX. Then who is the victim? If there is no victim, what are the two things that is required under the POCSO Act? The victim is central to the act, isn't it? So if there is no victim, why are you even investigating it? So please be very careful with regard to that. Then you went to the medical end. Ensure the doctors are also doing the same thing. The medical certificate is XXX. If you see that, please tell them, give it to me, I will mask it. Because you are in control, you are the investigating officer. You understand it? You have to ensure that it is not revealed, it is not disclosed. मलाई नाम त थाहा छ नि, उहाँको नाम पनि थाहा छ, उहाँको नाम पनि थाहा छ, म डिस्क्लोज नगर्नु भनेको छ, उहाँको नामै लिदिनँ नि त. तर मलाई नाम त थाहा छ नि, मेरो मेमोरीबाट हटाउनु भनेको होइन नि, हैन? So let us be very clear about what we are doing. Okay? And this is to both the trial court as well as the investigating officers. This mistake is happening at both the sides. Please ensure that we do not commit this kind of mistake. Right? Then you went further, you did the very good thing that you pointed out, this for our knowledge, that you are now investigating the case, doing search and seizure through the process of audio-video recording. Caution that audio, ensuring that these digital footprints do not get destroyed. Now, how can it be destroyed? Let's think about it a little bit. Investigation of a case takes, a POCSO case, how many months does it take?
2 months.
2 months, right. Filing of charge sheet?
That's within the stipulated time.
Within this period. Then, along with the charge sheet, you send this particular digital record, right? During the time of these 2 months, where do you store this pen drive or wherever that record is, the digital record?
Just to have this, the proper chain of custody, we always keep it in the Malkhana.
Malkhana. Now, is Malkhana the right place for custody of a digital record? I have seen your Malkhanas. I have seen your courts malkhanas also. What happens in the malkhana? What is kept in the malkhana? I have seen in the malkhana phalan ko bar, kaat ko muda, khukuri, bonsoro, bucket, everything you can think of is kept in the malkhana. Yes. So along with that, in a room which is not sanitized, right, it is kept in that, right. Then from one malkhana to another malkhana. That is the court's malkhana. I have seen your malkhanas also. Many occasions I went and saw the malkhana. It is the same thing. Now it is kept there, along with a horde of other things. And then it is produced to the court. When it produces the court, like if you have seized a mobile phone, right? When it is produced, it is just a box with no information there because it's already destroyed. Why is it destroyed? Because it has a life. The battery has a life. Earlier we could, in certain phones we could replace the battery. Isn't it? We could take out the battery and put it. But we don't have this. Now it's all inbuilt. Now the battery gets discharged. Over a period of time, if you don't use it, right, then it gets exhausted. Right? So by the time, I don't know whether the courts are taking pains to see the digital records, but by the time if they want to view it, there's nothing viewable. So when you seize this, what about the charger?
We do seize charger also.
You seize the charger. That's very good. But ensure that these digital records and footprints are well preserved. There are now rules which have been framed to ensure that these digital records are preserved properly. Make sure that we do that. It's very important. Chain of custody is very good. And everybody talks about chain of custody. The other day, a lawyer was arguing about chain of custody. The fact of the matter is, chain of custody going from one to the other is fine. I can see, yeah, it's gone very well. But then what is this? It's just a box. What is before me in the appeal stage is box. There's nothing I can see here. So what is the point of having this fantastic chain of custody? It just protects your duties. You've done your duty well, very good. But what happens to the evidence? It's destroyed. Are we really bothered about the evidence? And if we are not, it is high time we indulge ourselves in ensuring that this digital record is protected. It's very important for you. Right? So malkhana to malkhana doesn't really work that well. Okay? Then you are talking about further investigation, right? Please continue.
The seizure of valuable exhibits and all, and whatever that we seize in this crime scene, the evidences, there's biological and others, so we forward it to SFSL.
That's right. Again, in number of cases, blood samples have been taken, right? Swabs have been taken. It goes to RFSL. The report is, we can't find anything out. What is the purpose of that? So, where are we destroying evidence? Because we are collecting evidence, and if the evidence is not answering the question, then we are destroying it, isn't it? How are you destroying the evidence? You've taken blood sample, you've taken vaginal swabs, right? You've sent it for RFSL, but the report which comes is, we cannot find. Sometimes most of the report is, the blood sample is too less, or it has dried out, or there is nothing that I can find out. In every case, if the answer is like this, then somewhere we have failed the system. So how do we now ensure that this does not happen? Let's discuss this. I'm leaving it open to you. And this has to come from you. Yes.
Regarding blood sample and biological samples, when we collect the samples, it has to be preserved in certain temperatures, sir.
Correct.
We do not have that facility at PS level, and generally we send those samples to CFSL, sir.
So if you do not have it, okay, just address the issue. If you do not, you are in charge of a police station and you don't have it and you are collecting these blood samples or biological samples, then what are the steps that you are taking thereafter?
We try to send it as soon as possible to the forensic labs instead of keeping it at the...
Are you writing to the authorities to provide for these facilities? Don't you think it is part of your duty to do that? I'm a little blunt about these things. I'm sorry, right? I have at least myself written several judgments where I have implored the government authorities to do this for you all. But our judgments are to deaf ears. But a request which comes from you is very important, because you are the person who are on the top of your game. Right? Now, see, we cannot abandon it. I do not, it's like this. I have to write a judgment. Right? And I don't have the books with me. So I cannot read it. So do I now write judgment without reading the provision of law? Is that even a suggestion which you can give me? Go ahead and do it because you don't have a book. Write judgment, what do you feel like? You cannot do that, right? You will have to devise methods to ensure that these are protected. So how do we do that? Because it is not one case, but in multiple cases, I have seen biological evidence being destroyed or answered in the negative. And each time it comes, somewhere we must understand we are failing the victim. So you need to be that much more proactive. It's very important. हाम्रो सिक्किममा यस्तै हो, हाम्रो मालखाना यस्तै हो, हाम्रोमा छँदै छैन, गभर्नमेन्टलाई कति भन्नु दिँदै त दिँदैन. That cannot be an excuse because it's your duty. It's your duty and our duty and my duty. So how do we shy away from this duty? Be a little cautious. You are sending, sorry, I'll come to you. We are sending these samples to a particular, forensic institute which has a history of keeping it for 1 year, 2 years. The report comes after 2 years. All the samples have dried out, negative report. What is the point of sending it? There. So these are caution you have to take. Yes, will you ask me something?
So to this I would like to add something. Recently we had a case, I am posted at anti-human trafficking unit.
Don't talk about cases.
No. Just, this is okay. So what happened is, the same case, I have a victim and accused are not arrested. And during medical examination, the vaginal swab was handed over to me.
And what happened is, since the accused was not arrested and it's not arrested, the sample for comparison is not with me. So the sample, the vaginal swab with me, it's with me for almost now 2-3 weeks, almost a month. So what I did was, after 15 days or so, I through crime branch, I requested the director RFSL for the preservation. We can go for that also.
Absolutely.
Yes.
So if you think there is a solution.
Yeah, and to this, the director RFSL spoke to the CFSL Bhopal people. So how to go with the preservation? We have
the RFSL does have DNA fingerprinting, the tools are there, but is not active currently. Maybe after some time, like most probably we will be having DNA fingerprinting out here in RFSL also. But for preservation, we can request the RFSL for the preservation, and that's what I did. And since I have a sample right now, since the accused was arrested, so the mid of August, I'll be sending the sample. For that, I'll ask, request the director RFSL to hand over the sample. Then again, I'll make a requisition to Chairperson Bhopal for DNA fingerprinting. So that ways we can go for it for preservation.
We can do that, but when and what you really need to be cautious about is the chain of custody which you were pointing out.
Yes.
You know,
We do
you
have
have to ensure that chain, because you're now suddenly you're transferring the custody of evidence from an agency who is in control of it to an institute who is not in the investigating stage.
But
Right,
the chain of custody, I don't think so. It'll be broken or it'll be breached, because I'll be requesting the RFSL director through Crime Branch CID. So it's, I think,
Please
the
make
evidence
sure that
that
these are protected.
Yes.
So that's
So it's
very
better
important.
to keep it. It's better to keep it with them rather than keep it with us, because they have some, tools.
But I still urge all of you to go back and think about it, and maybe you can urge your authorities to provide each of the, at least the police stations with, certain designated areas where you can protect it.
Yes.
Lordship, this BNS is the specific provision, and breathing time for each and every state has been given to establish this forensic laboratory 5 years. And during intervening period, there is also proviso to request any one of the neighboring state to have to enjoy that particular facility by the crime branch of the respective state. That provision is given, and to put pressure to the department now, as of now, they may seek excuse like this, but the state government always seeks.
No, but we have a RFSL Saramsa, which is there, right? So we really don't know. And the problem is, neighboring state means West Bengal. When sample goes there, it comes after 2 years. All of you are aware. Mr. Jivan's constant turmoil. he doesn't get anything back from us. Yes. Yes, then continue.
So this, after forming the exhibit to SFSL, the recording of the statement of the victim by the magistrate, and once you get the copy, we submitted the charge sheet.
So what are the cautions that you take while you send the victim for examination of the victim by the magistrate?
The victim is not scared. I mean, there's not under pressure, especially that she's bound to take give the statement. So we have to ensure that. And usually, she's not accompanied by any police officers. Always on her free will, on her own will.
Sikkim is a very small society. Again, in my experience, I realized that in every case, there is somebody very near you who is interested in the outcome of the case one way or the other. We need to be a little cautious about that. It could be an officer with you, it could be your immediate superior, it could be your immediate junior, it could be anybody around. Society is very small, so we need to be a little careful. I don't want to elaborate more than that. I'm sure all of you understand what I'm trying to tell you. Be cautious there, okay? Then after that?
After all the formalities completed, we forward the charge sheet. That is within the stipulated time period, that is 2 months. So once we receive the SSL report, we submit the supplementary charge sheet.
This has become a format now. Supplementary charge sheet has become a format. isn't it? You're getting your, why are we not sending it to RFSL service? Except for DNA.
But here I think it doesn't take much time. So
why are you thinking of supplementary charge?
So usually this is what the steps.
I know, but it is happening more often than not. Because I have seen in the trial, charge sheet is filed and then supplementary charge sheet, the same witness is examined again and again.
That is...
The witness is examined after the charge sheet, right? Cross-examined, and then supplementary charge sheet is filed where the witness is required again. So he's brought back to the witness box and he or she is examined again. So I have seen records of the trial court where the same person is talking about the same thing in two different documents. In PW1 has spoken like this, in this, and PW1 is spoken again. Because he becomes an important witness to support your supplementary charge sheet. So he is brought back again. Right? So supplementary charge sheet should not be the rule. It is there so that certain evidence which is not been brought or has been delayed is brought out. But it cannot be the rule that for every charge sheet there has to be a supplementary charge sheet. This is something which because it poses a lot of difficulties. Right? It poses a lot of difficulties. When a witness comes to a witness box, okay, he makes a certain statement. You have to think of both the sides because you are unearthing the truth, isn't it? You are not looking at a situation where you have to, ensure that the person named in the FIR goes to the gallows. Right? You have to unearth the truth. Right? Truth could be varied. Now, in that particular situation, if a prosecution witness comes once and faces the cross-examination by the defense, the cross-examination has already disclosed the defense of the accused person. If the same person is given a second opportunity to come back again, maybe there will be a little bit of improvement, which may not be actually conducive to the truth. Right? So we got to be a little cautious about this position that you are taking. After charge sheet, supplementary, there is a provision for that. But these are more an exception than the rule. So don't take it as a rule. Okay? Yes, please. Okay. Right. You can sit down. What are the flaws or what are the problems do the trial court face while examining the charge sheet is a question which we need to address also, because this will be important both for the judges as well as the police officers.
Under the POCSO Act, Lordship, normally the charge sheet is complete. There is not much flaw. That is normally. But there are cases where there is no evidence supporting the birth or the age of the victim, which is the sine qua non for an offence of POCSO. I have seen charge sheet where there is absolutely no evidence, not even birth certificate, not even school certificate concerning the victim's age. So that is I think a vital flaw so far as the courts are concerned of taking evidence on POCSO. Number two is, as the investigating officers have already informed that under the new BNSS 2023, whatever served, Caesar, the recording of the statement of the victim. Now, recording of the statement of the victim is a different matter because because that is also done under 164 of the former code. But your search and seizure, which comes in the pen drive, that is a different matter. That is another important thing, because there are now instances of almost 70% of the cases where digital evidence has to be examined. Now, the children are vulnerable to the social media and digital evidence. So when the investigating officers collect digital evidence, this is from the court's perspective that I'm talking, you file a charge sheet along with a CCTV footage or a mobile phone camera recording or a voice recording with a pen drive along with a certificate, formerly under 65B, now 63. Now the certificate is a standard format. Now that I'm sure everybody understands, there is a standard format for the police, absolutely okay, there is no problem at all. But what you have to understand is that you have taken a recording from a mobile phone into a pen drive. You give a certificate saying that it is my mobile phone, model number this, IMEI number this, SIM number so and so. Absolutely okay for electronic evidence for a mobile phone. But what we have noticed in the court is that you don't explain in that certificate the process of how you have transferred from your mobile phone to the pen drive. Because most of the mobile phone, at least the mobile phones that I've seen, you cannot transfer it directly to a pen drive. It has to be done through some other mode, either through you download it in the computer or a laptop or any other device and then you save it in your pen drive. But what's happening is there is no information of how this transmission is done. How are you transmitting this particular video footage from your mobile phone to this pen drive? Now that will be a flaw so far as electronic evidence is concerned, and I urge from our side, that is one difficulty that we have when we take up and when we try to appreciate the electronic evidence, there is no information of this transmission. Please give that transmission also, that you had taken it through this particular laptop, the laptop number is this, the laptop owner is this, and this is how it was done. Otherwise, you will also have to give a 63 or a 65B certificate for this pen drive. So that is another vital question, Lordship, that I think the courts, while dealing with POCSO matters also, we have come to certain problems like this. But otherwise, I think more or less the POCSO Act cases, they come almost foolproof with whatever evidence the investigating officers have collected.
So these two issues which have been flagged by the learned principal judge, district session judge, we need to think about it. The first one which he talked about, birth certificate, but you have not produced the maker as a witness. You produced the school certificate, but you have not produced the maker as a witness. You've produced the victim, but you have not produced the parents who are alive to talk about the age of the victim. Three situations. Let's forget the law for the moment. What is that? Was that me or? Let's forget the law for a moment, right? When a child is born, who is the first person who knows about it? Sorry? A little louder. I am asking the police officers. They are investigating the case. The mother and the father. So why isn't it important for you to produce the mother to determine the age of the victim? In many cases I have seen, both are live but not produced. Right? Some of the cautious investigating officers are doing it, and that's very good. But I have seen many cases where the parents are not produced. Right? Let's understand the concept of best evidence rule. What is best evidence rule? It's a very simple concept, but that is seminal, in fact integral to both sides. If it is a document, right, the original is the best evidence. That's called the primary evidence, right? Who has prepared this document and who has signed it is the best witness to say that I have prepared this, right? So if you just follow the best evidence rule, you will produce the original and the person who made it. End of this document. In many cases, this is not happening. That's why the judges are now devising methods to protect the interest of the child by going and stretching beyond the legal framework so that your investigation is protected. But it should not be that. It should be that you produce absolutely foolproof material to establish your case. I'll give you another thing. You write a letter during the process of investigation. It's a legal situation, okay? You issue a letter to the principal of a school. You ask, please let us know what is the age of the victim as per the school record, right? And the answer comes from the principal saying, as per our school record, her age is this. Right? And you produce that. You are aware about, I can talk about the old law. I belong to that era. So, 161 statement. All of you know about 161 CRPC statement, isn't it? Is that evidence? What do you say? It is not. That's what you say. Or is it? What is the value of a 161 statement which you record before of a witness? Does it have any evidency value? Except for the fact that you have recorded the thing. What is written in the 161 statement has to be brought before the court in the witness box by producing the witness who has given you that statement. That becomes evidence. The 161 statement which you record is just your guidance. It is not evidence. Right? Now, if you read the second provision, 162, it says that particular statement can be used only for two things. One is for corroboration and contradiction. It can't be used for any other purpose. Right? If you look at, therefore, this communication which you wrote as an investigating officer to the principal in the process of investigation, and you got an answer, wouldn't be the same thing as a situation of 161. But the law is that you need to have a certificate from the school. I'm just throwing this question open. In every case you have done that, isn't it? You've written a letter to the principal of the school and you got an answer from the principal school. I have received your whatever letter, and in answer I say this is this. And that is produced as evidence in court. Have you given it a thought? the judges also can think about it. Usually these what you call letters are written under section 92. What is 92? CRPC? Section 92 CRPC. You write these letters under, are you with me? You understanding what I am trying to tell you?
91.
Huh? 91 ki 92? मेरो टाउकोमा चाहिँ 92 बसिरहेको छ तपाईहरुले 91 भन्नुहुँदैछ maybe you're right, I don't know.
94
Huh? Not 94, let's go back to the old law. Okay, it's 94. So what does 94 say?
Summons to produce document or claim.
So you issuing summons to produce document, right? And what is the document that you are asking them to do? Produce? Sorry? What is the letter that you write in your letter to the principal? What is the communication that you make?
So we request the principal to provide for a copy of the school admission register containing the date of birth of the child at the time.
Please confirm, the language is, please confirm the age of the child, of the victim. These are, I mean, roughly the words that you are using. And to that the answer which is coming is her age as per the school record is this. According to me, both are barred under the law. You are asking a question like you are doing to a witness. You catching a witness, calling them in the police station, please tell me what happened, and you are recording it. 161 says you cannot have it signed by the witness, but you are having that letter signed by the principal. And the principal is saying, as per my school record, the age of the child is this. And that is being produced as evidence. In 1 out of 3 cases, the principal also sends a Xerox copy of the school record. But in the 2 other cases, it is just a communication. So a communication is going from a police officer and a communication is coming from the principal saying, as per our school record, this is the age recorded in our document. Then you are also doing seizure of the register of the school. That's different, right? But I'm just focusing in this communication. It is the same thing as you are doing to a witness in a investigation. Are you with me? You are asking the question and the answer is coming. It is under 162 of the old law, and I don't know what it is now. See, what is 162 now of CRPC? It is barred. It can be used for only 2 purposes. I'm making it a little complex for all of you, so that you think about it now. And what I worry about is, it is a format that you are following. You've seen a previous letter which has been written in a particular way. So if the format is a good format written by a thoughtful police officer, you're following the right format. If you are, following a format which has not been thought about, then you're following the wrong procedure. I would rather that you apply your mind to the law, 164, and use that same words. So what does 164 say? Summons issued to the officer for
Correct? So why don't you write that? Please produce this document. Am I making myself clear?
Yes. Don't ask.
लर्डसिप मेरो चाहिँ के क्वेसन छ भन्दा चाहिँ यसमा चाहिँ हामीले स्कुलको प्रिन्सिपललाई रेजिस्टर हामीले चिठी काट्छौँ कि स्कुलको एडमिसन रेजिस्टर रेकर्ड प्रोभाइड गरिदिनुहोस् त्यो सँगसँगै एउटा सर्टिफाइड कपी पनि प्रोभाइड गरिदिनुहोस् र एज इन वेन कोर्टले तपाईँलाई मागेको खण्डमा चाहिँ त्यति बेला तपाईँले रेजिस्टर पनि लिएर आउनुपर्ने हुन्छ भने त्यो सही हो कि
एकदमै ठिक हो प्रोडक्सन अफ डकुमेन्ट त्यो तपाईँले मलाई सोध्ने होइन कानुन पढ्ने म त गलत आन्सर पनि दिन्छु बोल्ने मेरो काम हो बोल्छु होइन कानुन पढ्यो भने चाहिँ कानुन बुझ्नुभयो भने क्लियर हुन्छ नि त है 164 ले क्लियरली लेखेको रहेछ कि प्रोडक्सन अफ डकुमेन्ट तर तपाईँहरूको चिठीमा चाहिँ इन्फर्मेसन माग्नु हुँदैछ आरटिआई लेखेको जस्तै 94 होइन अनि त्यसमा अलिकति बी केयरफुल विथ द्याट यु नो आई डोन्ट नो वेदर दिस क्वेसन्स हेभ कम बिफोर यु आई वुड हेभ रेज दिस क्वेसन इफ आई वाज द लयर Yes.
Sir, now practice for this subject.
You can sit down, be comfortable.
Now we have started a practice where we raise a so like you said, now we have started a practice where we ask like documents in a particular manner, like you mentioned, and उनीहरूको रिप्लाई पनि on that basis नै दिँदैछ. If they are not supposed, if they are for an example, if उनीहरूले स्कुलको रेजिस्टर सबमिट गर्न सक्दैन भने they are justifying the मतलब why they can't submit the register भनेर पनि रिप्लाई गर्दैछ. At the meantime they are providing the certified copy of the जो particular admission register छ जहाँ चाहिँ त्यो सर्भाइभल गर्ल चाइल्डको डिटेल्स छ.
कानुन के हो 164 ले के भन्छ 94 सरी 94 ले के भन्छ व्हाट इज समन्स भनेको के हो इट इज अ पावर गिवन टु अ पुलिस अफिसर इन्भेस्टिगेटिङ अ केस टु समन रिक्वेस्ट होइन समन द डिफरेन्स बिट्विन रिक्वेस्ट एन्ड समन व्हाट इज समन That's right. It's a power given to you, directing the witness to produce the document. म दिनु सक्दिनँ भन्नु सक्दैन मैले कसरी भन्नु unless it is destroyed. कसरी भन्नु सक्छ It's part of your investigation. It is vital for your investigation. Why should it not be produced?
So they take a plea key, sir. They will produce the document as and when required before the law court. And the reason cited is since there are the entire history of the school is recorded in the register. So if particular case को लागि दियो भने चाहिँ they might be requiring something.
तपाईले इन्भेस्टिगेसन कसरी गर्नुहुन्छ त्यसको माथि निर्भर छ इन्भेस्टिगेसन डेस्कमा बसेर गर्नुभयो भने प्रब्लम हुन्छ बट इफ यु गो टु द स्कुल एन्ड आस्क देम टु प्रोड्युस इट द्याट प्रब्लम विल नट कम विल इट कम
Good afternoon, sir.
Yes.
So what the practice is, what we do.
मलाई प्र्याक्टिस वर्ड चाहिँ अलिक डर लाग्छ
सर हामीले के
यो प्र्याक्टिस भयो भने नि एउटा विभिन्न तरिकाको प्र्याक्टिसहरू हुन्छ यहाँनिर र एउटा उल्टा प्र्याक्टिस भयो भने त्यही चलेकै हुन्छ अन्टिल इज रेक्टिफाइड सो डोन्ट गो इन्टु दिस प्र्याक्टिस अन्डरस्ट्यान्ड द ल फर्स्ट राइट
Forget practice. के practice हुन्छ हाम्रो कोर्टमा पनि प्र्याक्टिसहरू हुन्छ जस्तै तपाईहरुको पनि प्र्याक्टिस हुन्छ I am aware of that. But the question to you is, when the law, which is that section 94, summons to produce the document, isn't it?
Yes.
Then you can issue the summons, right? But if there is an impediment, like what you say, it's a huge register, can't be brought, is that excuse not to produce it? Your job is to ensure and unearth the truth, isn't it? For that, if it is that difficult for them to produce it, can't you go there, see that, ask them to certify the certified copy, and you seize that?
So we do that. So
that's the end of the matter?
Yeah, so we
But I refuse to produce it.
What I mean to say is, one is certified copy they provide citing that they will produce the original register as and when required before the court. At the meantime, one is a certified register extract they provide that
investigating officer investigating officer. Suppose they provided you sit in your desk, they provide you a certified copy, right? And you go by the certified copy, believing whatever is there in the certified copy to be true. Are you really convinced?
Yes.
But if you had seen the original yourself, then that conviction would be 100%. So how do you want to be a police officer? What kind of police officer do you want to be? Convinced about the fact or partially convinced about the fact? That is dependent on you. सत्यको खोजमा अलिअलि असत्यमा डुबेको पनि त हुन सक्छ हैन अन्त त्यो चाहिँ त्यो जबसम्म तपाईले छानेर निकाल्नु हुन्न you yourself not be satisfied. That's the role of the investigating officer. त्यो तपाईको काम हो, that's your duty. So be satisfied before you file the charge sheet. You need to be convinced, because when the defense lawyer questions you, he says, no, I went there, I saw it physically myself, I have done it, I have videographed it. Who is stopping you from doing all that? Is anything stopping you from doing that? Your investigation has to be foolproof. You have to ensure that you protect your investigation with all your might. But if you are going to be a desktop investigator, and I am repeatedly using this, then there is a danger. You can't be sitting in your desk, being a police officer, in many of these cases, seizure is happening in the police station. The witnesses are coming to the witness box and saying, I was walking by Sadar Thana when the police officer called me and asked me to sign this document. Now, I don't know whether it is the truth or not true, but that is the evidence that has come. That is the kind of evidence we look at. Of course, it is keyboard. Satya khan sa tesma. To birth certificate to dulde aaya na wala dena. The birth certificate will be somebody else's house. तर तपाईले त समन गर्नुभएछ birth certificate चाहिँ पनि witnessलाई पनि समन गर्नुभएछ. And I am not blaming you, I am talking about this is what is happening. I have seen it in charge sheets. I have seen it in trial. They have conducted the trial. This is the kind of evidence that has come before us.
So normally the victim party, they get the birth certificate along with them.
Victim party get the birth certificate.
Yes, along with them, and we don't ask them to.
Kiन चाहिँ? Kiन त्यसै लिएर आउँछ victim party?
Maybe to prove like it's minor.
Nowadays
they bring the birth certificate.
As CJ, I'm seeing birth certificates attached with FIRs.
Attached to?
Attached with the FIRs, original.
But that's all right. They are being cautious. That's all right. But usually, in the natural course of things, investigation goes to every corner where the crime is happening and where we need to investigate, isn't it? It is not coming to your police station. How is seizure of what you call weapon of offense happening inside the police station? I've seen it. So you got to be a little cautious because, see, you will find different types of lawyers and they will question you. And if you don't have an answer and a blank face, that's the end of your investigation. Agar hard work ke khatam hoye na.
The other point I'd like to supplement is whenever there is a visit of the investigating officer to the place of occurrence, normally what is done is that you prepare a rough sketch map of that particular area, which is vital for the judge or the court or the defense to understand what was that particular place, how did it look, what is that area, whether it is populated, whether it is sparse, whether it is a jungle or a street or a town. Now, this was being done rightly by the investigating officers themselves. They were drawing it either themselves or through their subordinate officers or through one of the police personnel who go along with you. But you go there and then you get the rough sketch map. It is not exact, it is a rough sketch map. But now the trend is something like this, which I personally didn't agree to. The investigating officers now depute a junior engineer to go to the place of
I think that
occurrence.
must be their guidelines.
So it is mandated by the government.
That's right. Is there guidelines?
I do not know about their guideline. But what is happening is that the junior engineer goes there not with the investigating officer. The junior engineer goes with one of the police personnel from the Thana. The Thana person shows that this is the area. And what he does is he does a rough sketch, goes to his office, and then he gets it done in his Acrobat or whatever it is, the software. And then there is a printout and he gives that printout to the court. Now there is no distance. It is only that there is a small pocket, whether it is a forest. There is no distance of this area or that area or this house or that house, which the investigating officers, they do it very well when they prepare a rough sketch map. Now that is becoming very, very difficult, I think, for the courts, because the question is, when the investigating officer is asked this question, that what about this particular rough sketch map? You say that we don't know because there is somebody else who's gone there and prepared this map. Now the investigating officer is asked, what is the distance between this road and that place of occurrence? He says, I do not know because it is not written in the sketch map at all. So I think this is one law which I thought I should bring it to the notice of the investigating officers.
Can you hand over the mic to us?
Good afternoon, Lordship. This might not be very problematic henceforth, but I would just like to inform that in certain cases, when the IOs have filed the digital evidence along with the charge sheet, they file it in series. And what happens is, by the time we are trying to read the CD in the courtroom, it doesn't read. I mean, it's unreadable.
That's exactly what we talked about.
Yes, that is one is there. And another one is in cases of POCSO where the victim has delivered a child and an accused is there, only one accused is there, and then the forensic report comes back and then it shows that the DNA is not matching with the accused. After that also, the charge sheet is filed against the same accused, saying that he is, if not the father, then at least the sexually perpetrator. And then in the trial, what happens is maybe because the victim wants some kind of child support from the accused, saying that he is the father of the child, she says that no, he is the only one with whom I have had any kind of sexual physical relation. So that completely discredits her statement regarding any kind of sexual assault. So in that case, I think the IOs should go forward and then ask the victim with regard to any other possible accused persons, because obviously the DNA is completely going against her case, right? So that is also something which is lacking, I believe.
You know, again, we'll go back to the first issue, then we'll talk about this one. regarding what was pointed out about the rough sketch map. What's the purpose of preparing this? Just understand it. Why do we prepare a rough sketch map? Everybody does it. Everybody who has investigated a case has done it. Any of you who have not done it? All of you prepared rough sketch map. But why do you prepare it?
So to place a crime scene before the lowly judges.
That's right. Now, isn't there something more that is required besides placing it? It needs to be proved also. Correct? Because the judge is not going to go to the crime scene. So he has to understand what the crime scene is about. Right? So what is the relevance of the rough sketch map? It reconstructs the crime scene. That's right. It's a very large kind of words that you are using. But let's go to the detailing of it. Why do we need it? किन चाहिँ चाहियो रफ स्केच चाहिँ विटनेस आएर बोलिरहेको सबै कुराहरू भनिरहेको छ डकुमेन्ट इम्प्रुभ गरिरहेको छ फोटोग्राफी इम्प्रुभ गरिरहेको छ त्यो रफ स्केच म्याप चाहिँ किन चाहियो Take out the rough sketch map. How many of your judgments have you connected the crime with the criminal through the rough sketch map? I'm taking your... None of it, none of them. So, what is the relevance of a rough sketch map?
In motor accident cases, it is very important. In fact, like I had to acquit one person because the IO did not array the witnesses to the sketch map. If the witnesses were there, I would have definitely convicted that man because when we, like, I mean, we cannot take away the fact that the Motor Vehicle Act is actually being applied in a mountainous, road and mountainous terrain when we talk about accidents in Sikkim. So the degree of caution which is required while driving in a mountainous state or a mountainous road is much more than thick. But because of the lack of the sketch map, I could not think. Had the sketch map been there and the witnesses were arrayed, that person would probably have been convicted.
So what I understand from this deliberation is the rough sketch map is used for many purposes. The learned judge was pointing out the distances are not mentioned. Where distance is relevant, it should be mentioned. Right? He's talking about a mountainous thing. If that is important, it should be mentioned. Right? So the purpose of rough sketch map is to basically give exactly the scenario as to how this crime happened and where it happened. Isn't it? Because where it happened is important. You mark what? PO that is place of occurrence. Right? That's the relevance. Now whether you do it through an investigating officer, it should be done by the investigating officer in the first instance because you have to come and be absolutely in control of the investigation. Because if you depute too many people, right, who may be not in the same thought process, like you employ a junior engineer to do that. His job is not investigation. He doesn't even understand investigation.
He doesn't even know that is the place.
That's right. That's right. Right? Now, see the situation that it is creating. And I put this very interesting point, I keep talking about it, I've talked to most of you about it. When you just imagine the rough sketch map which you prepared. यहाँनिर एउटा बाटो छ हैन माथिपट्टि एउटा घर छ तलपट्टि पनि एउटा घर छ बीचमा रुखहरू छ हैन यहाँनिर गाईको गोठ छ है गाईको गोठको छेउमा चाहिँ मान्छे मारेको यहाँ चाहिँ प्लेस अफ अकरेन्स भनेर यसो दिनुभयो हैन That is how you do the rough sketch map. Have you all imagined this? Right? Who is prepared it? The investigating officer. Right? Our investigating officer visits the place of crime, right? So he goes to that road, he's traveling on that road, he sees that road, so he can talk about it. The road can jam up. You wrote someone, right? माथिल्लोपट्टि घर छ उसले पनि देख्यो है, त्यो पनि उसले भन्नु सक्छ। तल्लोपट्टि पनि घर छ त्यो पनि देख्यो उसले सेकेन्ड टाइम जाँदाखेरि है, देख्यो त्यो पनि भन्नु सक्छ। देन अलिपट्टि अगाडि 4वटा रुख थियो त्यो पनि ड्र गर्यो, त्यो पनि भन्नु सक्छ रुख छ भनेर है। त्यहाँदेखि अलिकति उता गाईको गोठ छ त्यो पनि उसले देख्यो, त्यो पनि उसले भन्नु सक्छ। त्यहाँदेखि डल्लो पार्नुहुन्छ तपाईँहरूले, PO भन्नुहुन्छ, त्यो चाहिँ कसरी भन्नुहुन्छ? हजुर कसले भन्यो? Correct. Whereas for all the other things that you saw, you are the primary witness, you are the best evidence because you saw it happening. You saw not happening, you went to that road, you saw the road. The existence of the road you can prove. The existence of the house you can prove. The above and below, the existence of the trees you can prove. You can prove the existence of the Geico goat. But the place of occurrence you mark because somebody else had told you. In a rough sketch map, that is the only hearsay evidence that is in existence. Do you realize the importance of what I am trying to tell you? If you do not get that witness who told you that this has happened here, to the witness box during the trial, the rough sketch map which you beautifully drew with colored markings and rato pen, below beautiful handwriting, dollo pani perfect dollo pareko, kehi फाइदा छैन। त्यो witness आएन, कहाँ भयो त्यो काम त? See how Evidence Act plays out in investigation. What you've been doing over the period of so long is all gone because that is hearsay evidence. Somebody else has told you. So you have to ensure when you make this thing that the investigating officer who drew the sketch map is in the witness box and deposes about all this, and the witness who pointed out the place of occurrence also comes to the witness box and talks about, you show it, the PP shows that यो point चाहिँ यही ठाउँमा भनेर तपाईले भन्नुभएको हैन आयोलाई, then your rough sketch map will serve its purpose. Otherwise, it is left to the vagaries of bad defense lawyer and etc. etc. सानो सानो कुरामा एभिडेन्स एक्टले तपाईहरुलाई घोचिरहेको हुन्छ, चाल पनि पाउनुहुन्छ। I would think of it what the then principal district judge said. लाई तपाईले ल्याउनु भयो, that is under some guidelines. I don't know why. What is the reason? Do you have any idea why J is coming into the process of investigation? किनभने तपाईहरुको ड्राइङ चाहिँ राम्रो भएन, good not good artists.
Maybe there will be problem in BNSS.
What does BNSS say?
BNSS says they are now police officer is required to take the assistance of the expert. We are not expert so far the drafting is concerned. It's my, I think, presumption. So by virtue of implementation.
No, but they should know why are you which guideline are you following? There suddenly JEs are coming. You are the one investigating and you are producing JEs. So why are you doing that?
There is a notification, sir.
What does the notification say?
That we have to review or request to draw skilled site map.
On the Tetivalas got back, let us say, presume for a moment that his government order is correct. Now, how do you take it forward? You tell the junior engineer, go to this place. सामदोङमा गएर त्यो कान्छाको घर छ, त्यो कान्छा घरको मुनतिर गएर नक्सा बनाएर आउनु भन्नुहुन्छ कि के भन्नुहुन्छ?
Sir, there's a problem because they don't come immediately.
त्यो त अर्को प्रब्लम हो। तर तपाईँकोमा आयो भने चाहिँ तपाईँले के भन्नुहुन्छ? जाऊ गएर त्यहाँनिर गएर So you go there. The investigating officer is in control, isn't it? That's very important, right?
Because otherwise they would have any idea how to, go about
There. The London judge is pointing out it is not the IO, it's a constable who accompanies the JE. Your desktop investigation हो भन्छु नि तपाईँहरूलाई, अलिकति cautious हुनुहोस् तपाईँहरू. The moment we become desktop investigators, this is the end of your journey as an investigator.
There is a problem. Soon after publication of notification, whatever guidance being now issued by the state government, simply they are throwing on the head of the police officer without any training, without any guidelines per se. So they on and on use their now the IQ and implementing it.
Now you have to train J's in investigation.
Plus they are now required to give some sort of now the training because how to prepare, how to go ahead. Because the expert plus the forensic expert and IU of the case, both are taking up.
Correct, that's something completely different.
The IU of the case and the forensic expert, both are now going to the spot and picking up on and on the evidences. And there is no SOP. Who will go first and who will go second?
No, forensic expert is part of a team. He's always done that, right? It's always, they go with the police officer.
There is no separate judicial.
Picture हेर्नु न तपाईले. Picture हम त्यसै आउँछ पानी. Investigating officer ले forensic expert लिएर जान्छ. That's the correct way to do it according to me also. For drawing something, unless you are a terrible artist, if the IO feels that mode, नक्सै बनाउनु सक्दिन भनेर त अर्कै कुरा हो.
There is notification now. They cannot overdo.
I just recently watched a video in YouTube where an investigator had connected the amoeba in the water, in the PO, with the disease, and that led to the conviction. Now, the sketch map in those kind of cases are important, but then we have to reach that level of investigation, I guess.
No, there is something, as far as forensic investigation is concerned, I'm telling you very, very clearly, Sikkim is lagging behind. In my journey as a defense lawyer, as pointed out by the director, for almost 25 years, and now as 8 years as a judge, if memory fails me, I do not know, but I haven't come across a single case where fingerprints have been produced as evidence. And I asked myself this question, was it available? Should it be available? And my answer is yes. I have written a judgment some time back. It's called Suren Rai, I think. No judgment came from your court? Jyoti, isn't it lumberjacks? I remember the words. West Coast. In a case arising out of West, now that the case is over and we can talk about it, the two persons were hired by the landowner to cut trees. They were staying in a small shed. राति रक्सी पनि खाएछ, झगडा परेछ, त्यसको लागि घडीको लागि केसको लागि मोबाइलको लागि झगडा परेछ, एउटाले काटेछ अर्कोलाई र राति भागेछ. बिहान ओनर जाँदाखेरि त्यो शेडमा रगत एउटा ठाउँमा मात्रै हैन, it was splashed on the tin shed all over. It was in the blanket, it was on the floor, it had, yet the accused had left behind his chappal, which was also filled with blood.
The chappal marks were all over the floor till a particular point of time, and there was no evidence collected. I didn't see a fingerprint. There were bottles there, there were mugs, there were all kinds of things.
That's prior to incident, the owner of the owner tried to amicably settle the matter and failed to settle the matter, and accused left the place that was seen by
That was not part of the evidence.
Yes, that's it.
Was it?
Yes, that's it.
I don't even know.
Because on that ground only
Okay. But what I'm trying to tell you is, why isn't it available? It is there. But why are we not exercising this power of investigation? Why are we not lifting fingerprints from the scene of crime? How are we not able to connect the crime with the criminal when so much of glaring forensic evidence is left behind? It shocks my thinking. And then I see all these movies. I watch a lot of crime thrillers. The last one I watched was something to do with DNA. I forget the name, but all of you must watch it. Okay? It was about DNA profiling. And you've seen it. No?
I watched, I forgot the name of the movies.
It was on Netflix, I think. That's right. So, I mean, good, you also watch movies. But it's very important to watch movies. It gives you, ideas. I realize that, DNA is such an important thing. All that we do for DNA is again. DNA. 90% of the cases okay. But DNA profiling is used to connect the crime of other heinous crimes as well, which we are not doing. So I think, all of you need to train yourself in the forensic sciences and understand it better so that you can give us good evidence in the court. We are losing a lot in everything. Every murder case, okay? Seizure of luga, accused ko luga, victim ko luga. Then in blood sample, dunga mati, onipuri mati, right? These are the forensic evidence that you collect. In one case I saw hair, but it did not connect to anybody. So it has to give result. When you collect evidence, it is for a particular purpose. Collect hair, but for what purpose? If you are not guiding the investigation to come to a conclusion, then hair why are you picking up the hair from the scene of the crime? You could ask yourself this question. Kapal paunu bho, blood pani cha त्यसमा, त्यो तपाईले लिनु भयो, कसरी त्यो किन चाहिँ निकाल्नु भयो? Why are we taking this hair out? It could be either of the victim or the accused. Then you will have to take hair samples of both. But you do not do that. I have seen cases in which blood sample is taken from the floor, but the blood sample of the accused is taken, which does not match, and the victim is not taken. So somewhere the story is not unfolding in incomplete investigation. Alikati detective movies of gives you a lot of thinking that is required. That very interesting case, I don't know, I forget the name. There was another one which I think I mentioned to you also, no? About this child, what you call accused. They're very, very popular. What was that? Adolescents. Have you seen that? Go and see it. You will find
how investigation has its relevance from that movie. You know, it's so important. Things which we have to go beyond everything to prove your case is taken so matter of factly over there in that particular, you know, movie. So I think it's a very good movie for all of you to watch also and understand the nuances of good investigation. I'm not saying you are a bad investigator. I'm saying to improve further. Then what Ranjita ma'am was pointing out, and what was it that you flagged?
The DNA of the
DNA, that's right. And this is a case which has happened, at least in my court, twice, right? You have connected the accused with the victim of sexual assault, and the evidence reflects that he is the criminal. He has committed the crime. The victim also says that I had sexual intercourse with this man once on this particular day, right? And then you send it for DNA. And in the DNA report, there is no connection because the child is somebody else's. What happens to that investigation? Can he be found guilty? Unless there is material to show that the commission of sexual offense was multiple times. But that is not in the evidence, so that is what she is talking about. So you got to keep thinking as to what happened. To unearth the truth is very, very important. But truth is not always in black and white, isn't it? You have to understand that. So please ensure that you understand the story as it unfolded. And if you bridge these little gaps, maybe the result will be much better. So that I think, anything else that you want to talk about? You had a number of questions, you said. The law is gender neutral, yes.
Gender neutral. Sir, यसमा चाहिँ के हुन्छ भनेदेखि victim कोही बेला victim अनि accused both are minor. Minors भनेदेखि कसैको complaint आयो या एउटा फ्यामिलीले complaint गर्यो भनेदेखि चाहिँ एउटा मात्रै केस रेजिस्टर गर्दैछ अहिलेसम्म चाहिँ यो चाहिँ साइमल्टेनियसली दुईटा केस रेजिस्टर गर्नुपर्ने हो कि एउटामै किनभने उनीहरुको if they are indulged in sexual activities with their consent.
Consent of a minor is not a consent at all.
Exactly.
But when both are minors, then who is the victim and who is the perpetrator of the crime? How will you answer that? You are asking me the question, but you are the investigator, not me.
Sir, त्यो चाहिँ अहिलेसम्म चाहिँ एउटा मात्रै केस रेजिस्टर गर्दैछ.
होइन, त्यो त तपाईको केस त रेजिस्टर हुन्छ नि त. पोक्सो एक्टले चाहिँ के भन्छ त? पोक्सो एक्टले पो भन्नु पर्यो त. So what is POCSO Act? Let's talk about the offence. There has to be an offence, right? No? What does take any offence? You have the POCSO Act with you. पढिदिनुस् न, एउटा offence पढिदिनुस् न.
So section 7, sexual assault. Whoever with sexual intent touches the vagina, penis, anus or breast of the child or makes the child touch the vagina, penis, anus or breast of such person or any other person or does any act with sexual intent which involves physical contact without penetration is said to commit sexual assault.
So with this definition, in your scenario, the victim I can understand, right? But who is the perpetrator of the crime?
First, the one who initiates that first.
So according to you, if there are two children involved in a sexual act, one of them will be a criminal, a juvenile criminal. I am throwing the question back to you. You said it is registered, isn't it? On what basis did you register it, is the question. No, it is registered according to him. There are two children who have indulged in a sexual act, right? Consent of either is no consent at all, right? So you register against whom?
Sir,
the girl or the guy?
Complaint उसकोबाट आउँदैछ सर त्यही मात्रै सबैले रेजिस्टर
कसरी रेजिस्टर गर्नुभयो इज द क्वेसन दिस डेलिबरेट on it कसरी रेजिस्टर गर्नु
The sexual offense was committed. That's why the case got registered.
by whom cognizable offense is committed, isn't it? So who is the criminal? There has to be a victim and a criminal. You got to identify them, isn't it? So how did you register it? On whose complaint?
Or a medical officer?
Complaint to कसको आयो?
गार्जियनले कम्प्लेन गर्छ नि सर
त्यही त भनेको त कसको गार्जियनले चाहिँ
जेनरली अब केटीकै आउँछ सर केटीकै गार्जियनकोबाट तर
अब केटाको गार्जियनले आएर चाहिँ तपाईलाई कम्प्लेन गरेर के गर्नुहुन्छ
त्यो त रेजिस्टर गर्नुपर्छ
त्यो पनि गर्नुहुन्छ
हजुर कम्प्लेन्ट आयो भने त गर्नै पर्यो सर कग्निटिभ केस
what is your understanding?
तर अब दुईजनाकै सर कन्सेन्सुअल सेक्सुअल एक्टिभिटिजमा
consent to कुरै छैन minor consent is no consent
त्यही कन्फ्युजन भयो सर अहिले चाहिँ के गर्नु चाहिँ बेटर
अब आन्सर पनि निकाल्नु पर्यो नि त कन्फ्युज मात्रै भएर भएन त अन्त तपाईहरु कन्फ्युज भयो भने हामी कसरी हेल्प गर्ने अब कसरी चाहिँ you tell me who is the criminal and who is the victim in this to the confusion okay
What happened within my jurisdiction is that there was an FIR brought regarding the same what's our manager and gentleman. The victim and the perpetrator both are children. In fact, they are the brothers and sisters. So the registration of the FIR was done against the brother. So I questioned the SJA on what ground did you register against? Because both of them are minor and which them are the victims. Because sexual offences committed to both of them by themselves. So on what basis did you do it against the brother? Then the answer was that because the sister delivered a child, that's why she is the victim and the brother is the perpetrator. I said just because of the genitals which a male has, that cannot be the ground of you having registered.
Very feminist church.
Because both of them are minor. In fact, the brother was younger to the sister. So till now, and there's no another FIR that has been registered against the sister.
But you have to get the answer. Why? Who is the victim and who is the perpetrator of the crime? So that's your investigation, isn't it? We can't say you do this. To the victim को हो र क्राइम कसले गरे त तपाईले खोज्नु पर्ने हैन त कि हामीले खोज्नु पर्ने हो जजहरूले
त्यो क्वेशन नसकेर सोधेछ
अब कसरी खोज इन्भेस्टिगेसन गर्नु भएन भने कसरी खोज्नुहुन्छ कसरी आन्सर पाउनुहुन्छ You getting what I'm trying to tell you? I'm trying to help you here, right?
Right.
You need to investigate, right? And what is the result of your investigation? What have you found? What happened?
POCSO केसेसमा चाहिँ सरको भन्नुभएको जस्तो त्यस्तो केस पुरा हुन्छ सर आई एम फ्रम राउन्ड
it is very, very natural for young adolescent kids to indulge and be curious about sexual activities, and they will indulge in it. Some get noticed, some don't get noticed. That's the only difference, isn't it? But the question to you is, POCSO Act is meant for a particular purpose. What was the purpose of the POCSO Act? But in the back of the POCSO mind, who are the perpetrators of the crime? POCSO Act पढ़नु हुँदाखेरि तपाईले कि what is the theme of the POCSO Act? That's right, to protect the children from whom? From sexual offense. The act as the act, but from whom? Slowly the answer is coming. From adults. Is that what you think? But the offense does not talk about adults. Whoever commits murder. Right. So in a case of this nature, who is the perpetrator of the crime? Who is the one who is the victim? Is a question which the investigation will have to answer. Not the analysis of the law. If a juvenile has committed a sexual act, right, which according to you is an offense under the POCSO Act, then you will have to file the FIR and register it and investigate it. But when there are two juveniles involved, how are you going to deal with it?
सर यस्तो केसमा हामीलाई प्रब्लम के छ भने सर म्युचुअल कन्सेन्ट हुन्छ सर दुईटै पार्टीको गर्ल चाइल्ड
करेक्ट म्युचुअल कन्सेन्ट त हुन्छै हुन्छ
मोस्ट अफ द केसेसमा बिहा पनि भएको हुन्छ
हुन्छ in fact in many cases you will find cases where a 19-year-old is indulged in sexual activity with a 18-year-old who is a minor, right, with consent. This is happening. With a 16-year-old, it is happening. With a 15-year-old, it is happening. They are having children. It is happening. They are getting married. It's happening, right? The question is not that. Now, how are you going to deal with it? Because this is happening in a society which you need to protect. Don't throw the ball at the court. You need to apply your mind. I'm sorry if I give you answers, then you may take it this way or that way. The judges are saying adults must be the perpetrator of the crime. But what is your thing? Who are you protecting? Or you just randomly protecting everybody? In a POCSO case, who are you protecting?
Children.
Children, right. Now, when both are children, then who is the perpetrator and who is the... There has to be an offense, another. Offense again over this man. When two are juveniles. In the traditional offense, एउटाले चाहिँ खुकुरी लिन्छ अर्कोलाई चाहिँ काट्छ नि त हैन कि कसो the person using the kukuri is the criminal and the person who suffered the kukuri is the victim. But here they are indulging in sexual activity, both are juveniles. So what is your answer to that? Is there a crime? Yes.
Lordship is they are now going through the provision of the POCSO Act, not able to find out. These are the practical problem now we are coming across in this society. So by going through many judgment, many SOP, they have many issues, and they consider one from Lassi they derived from the SJA Act is child in need of care and protection. The victim is child in need of care and protection, and the whosoever is committing offence is child in conflict with law. So, taking this particular concept in mind, they have to make the investigation and have the charge sheet in appropriate for like JJ for responsibilities.
Do you agree with the judge? You have a right to disagree. So you are the investigating officer. Think about it and just
Children court, they can file the charge sheet.
Your intention has to be there.
Oh, sorry, this is my audit solution was that they can identify the victim as child in need of care and protection, and they know the child who has committed offence, child in conflict with law, and file the charge sheet before JJ.
So if you look at the Juvenile Justice Act, who is in conflict with law can also be tried as an adult. So they are capable of committing crime, that is very clear, isn't it? That's why they are in conflict with law. But they have to be tried under a special act, or they can be tried as an adult if the board comes to the conclusion that he was capable of acting as an adult. Right? So it is very clear that a juvenile can also be indulging in sexual crimes. That much is clear. So the POCSO Act is gender neutral, as you said, right? It does not specify anywhere that the person or the perpetrator of the crime must be an adult. Does it say that? We presume that. We presume that. Right? In a case like Nirbhaya, let us say, right? If Nirbhaya was a minor, right, it could still be tried as a criminal case. Correct? A juvenile, that's how you know the Nirbhaya case in Delhi, right? It is because of that the Juvenile Justice Act was amended and the POCSO Act was amended, and now even juveniles after a particular age can be treated as an adult and tried in normal criminal courts, right? The issue which is before us, however, is something different, right? You are talking about consensual act between two victims. Then in a Nirbhaya scenario, it is rape. So let us take one juvenile commits rape upon another minor, then it is rape. But if it is a consensual sexual activity, then both are victims. And I am not giving you a judgment. If you file a charge sheet and then the trial court looks at it, maybe in my lifetime as a judge I may have to pronounce on it. But I am just making you think. But in this situation, both are victims. So the question to you is, and the ball is in your court right now because it has not come to the court to deliver a judgment. You have to register a case. How will you register a case? And who will you register a case against? If the person who filed the complaint says that my child was raped by a juvenile, then of course is very clear. But if, according to you, it was consensual, so what was the complaint before you? They indulged in complaint, but what happened? They consensual sexual activity. And one case, no, that's her case. His case is different. Then what happens? And how कसरी चाहिँ रेजिस्टर गर्नु त्यो केस त्यहाँ नै अड्केको त हजुर हजुर बुझेँ रिलेसनसिपमा हुन्छ त्यो एक्ट
Yes sir. हुन्छ अन्त चाहिँ
कम्प्लेन्ट चाहिँ कसरी लेख्नु कसले लेख्छ
प्रेग्नेन्ट हुन्छ नि सर गर्ल चाइल्ड चाहिँ प्रेग्नेन्ट हुन्छ हस्पिटल आएको हुन्छ सर
त्यो त हो कि
18 कम्प्लिट भएको
बट इज बिकमिङ प्रेग्नेन्ट अ क्राइम
नो सर
व्हाट इज द क्राइम
सर
द सेक्सुअल एक्ट
प्रेग्नेन्ट हुनु पनि क्राइम नै हो सर एज पर पोक्सो एक्ट अन्डर एज हुँदाखेरि सर
खै कसरी भयो कुन चाहिँ प्रोभिजन पोक्सो एक्ट आउनुहोस् त
Make someone pregnant, sir. Aggravated sexual assault section I think 6 होला सर
के भन्छ
यसमा चाहिँ कसैले सर माइनर चाहिँ प्रेग्नेन्ट गरायो भने चाहिँ अफेन्स हो सर
ओके
सो जेनरली त्यस्तो हुन्छ बस्तीतिर चाहिँ उनीहरू प्रेग्नेन्ट हुन्छ माइनर हुन्छ हस्पिटल
then it is not a crime according to you
नो सर
सेक्सुअल एक्ट गर्यो त्यो चाहिँ क्राइम होइन प्रेग्नेन्ट भयो भने चाहिँ एक्ट खै प्रोभिजन पढ्नु नि त तपाईँहरूले मलाई डरलाग्दो क्वेसन भन्नुभयो कुन चाहिँ प्रोभिजन अरे J2 5J2 is what is it पढ्नुहोस् त यो जे चाहिँ तपाईँले राम्रै जे पढ्नुहोस् न छ तपाईँकोमा दिनुहोस् न त 5J
Section 5J POCSO Whoever commits penetrative sexual assault on a child which number 1 physically incapacitated
बुझ्नु भएको फर्स्ट पार्ट चाहिँ पेनिट्रेटिभ सेक्सुअल एसल्ट चाहिँ
Section 5 aggravated penetrative sexual assault
That's right. So whoever commits penetrative sexual assault which results in pregnancy, then under that provision there is a higher offense. That's all. I know. But the penetration is important. That is the crime. So we are going back to the same question. तपाईहरुले एफआईआर चाहिँ कसरी रेजिस्टर गर्नुहुन्छ त्यो त तपाईहरुले सोच्ने काम हो नि त हामीले सोचिदियो भने त फेरि खतमै गर्दा No, just raise your hand. How many of you will register an FIR? 1, 2, 3. Rest of them are hesitant. Majority is hesitant. You are in the minority. Minority may be right. Who will you register against? Now let me ask the minority. Who will you register against when it is consensual?
Sir, consensual will come during the investigation of the case. The consenting, it won't come in the FIR. It will come during the investigation. And that too is...
The FIR will always make an allegation against somebody.
Of course, sir. That's why cognizable thing will come.
But if there was a FIR which says consensual and made my daughter pregnant, now
that is rarest of the case. The victim party won't blame the victim herself like she.
According to him, the pregnancy is the problem. I know. प्रेग्नेन्ट बनाइदिएर त एफआइआर लज गर्यो, प्रेग्नेन्टसम्म त केही पनि भनेको छैन नि त। प्रेग्नेन्ट भएपछि चाहिँ त्यहाँदेखि पो रिलेटिभहरू उफ्रिन थाल्यो होइन त?
While a sexual act is normally like between juveniles or whatever minor, so it won't come in front until and unless it is checked by someone. If the school, for example,
correct. That's a practical way of looking at it. Correct. So it always comes later. That's right. But the question to you is: suppose an FIR is registered, right? Which says they fell in love, hypothetical situation. They indulge in sexual activity consensually, but my daughter got pregnant. Now register a case. Now what do you do?
In that case, only the boy can be held accountable. Even only a girl can get pregnant.
if the pregnancy is the crime, correct?
That the section says in case of a female child makes the child pregnant.
Huh.
Only a female.
No, it doesn't say that. Please see that. It says whoever commits penetrative sexual assault on a child, which in the case of a female child makes the child pregnant as a consequence of sexual assault.
Only a female can get pregnant, so obviously the boy has to be
held accountable.
Now we're getting the answer. So now in that case, you will register a case against the boy. Is that fair?
Nothing is fair in this minor thing.
You're right. No, but here it is. If it is J2, then it has to be registered against a boy. It is no. That can't be a complaint against a girl, because what his problem is that the girl has become pregnant, and because of the pregnancy, the relative or the father or the mother has gone to the police station and asked them to register a case against the boy, isn't it?
But the question to be ascertained, Lordship, is
No, penetrative sexual assault.
there has to be sexual assault, not an act. The fact of assault has
That's a very important point. That's a very important point, okay? But if you look at the POCSO Act a little deeply, the heading is assault, right? But the definition is nothing to do with assault. What you understand as assault is different from what the POCSO Act understands as assault. And your understanding of the assault is vis-a-vis a crime committed by an adult. Upon an adult. But here, if you look at the POCSO Act, it's the only two words which is used, or three words which is used, is sexual assault or penetrative sexual assault. But if you look at the definition, where is the assault? When you touch somebody, where is the assault? In the traditional sense of understanding what is an assault.
There is a lacuna in this.
No, there is not a lacuna. There is the intention of the legislature. That's right. It's a completely different thinking process. So, if you try to understand sexual assault in the manner you think traditionally, then we are going horribly wrong. That's why it is called a special act. Mahima, you have nothing to say? Very quiet.
No,